Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to be continuing our coverage of Shanda Vander Ark, her Ginther hearing, Part 2. Part 1 was November 25th of 2025. Part 2 is today. Thank you so much. And let's get started. Grab a seat. Hello and welcome to Trial TV Live. I am the Squeegee. All right, welcome in everybody. How's everybody doing today? Good to see you. Let's see, Camilla, you've got your son's 18th birthday today. Did I just see that? Where is that? Yes, 18 years old, special D&D day. Awesome. Well, happy birthday to your son, and I hope his day is a good one, and he has fun playing D&D today and or tonight. Brett, good morning to you. Sherry, Green-Eyed Cat, good to see you. Good vibes only. Welcome in. Tony Green, hello. Nana, good to see you. Mallory, happy Friday to you. Red Snap, KS Granny, good morning, good morning. Richard, good to see you. Raj, Selena K, welcome in, guys. Linda, JMS, Vicky, good morning, good morning. Teresa, good to see you. Heidi, hello, happy Friday to you. Alex the Dane Mom, good morning. JMS, 37 degrees in Connecticut. It's supposed to be 50. All right, that's not too bad, right? That's not too bad. Sherry, good morning. I hope all is well with you. Shirley, looks like spring will never show up. Yeah, today's spring, right? Yeah, today's the first day of spring. Selena K, 83 in Utah. You're breaking records. Yeah. Dream Horse, did you catch the Afterman piece on the Daily Show? Oh, we'll have to watch that. No, I did not see that one. Joy, good morning. How are you? 90 degrees in where Linda is. Oh, you need to move to Arizona. Gotcha. Brad, any guesses on what reason she will give to disrupt things this time? I'm sure she's going to fall back on her sickness. She seems to do that a lot. Alice, good morning to you. That reminds me, I wanted to thank Fur Baby's mom, Alice, Debbie, and Texas Cat for sending us food. I went to the post office yesterday. I picked up Roger. I got him from the vet. Well, actually, I went to the post office first, then I picked up Roger. And thank you guys so very, very much. We got toys, we got food. So really, really appreciate it. The cats love all the food that you guys sent. we're going to hold off on one of the toys. There was a toy that we got last week that Sid has just completely, she has claimed it. And I posted that to our members only of her playing. I did a slow motion. So if you guys haven't seen that, I posted that. But we have another toy that we're going to hold off until Roger feels a little bit better. So it was an interesting evening last night, to say the least. We didn't get to bed until 2 because the medicine we gave him, it was supposed to calm him down, and it was a painkiller, but instead it was like he was just going crazy. He literally was like just flopping around, and anyway, so we didn't get to bed till 2. So it was a tumultuous night for us. Mr. Mike M, good to see you. Stand for the truth. Good morning to you. LWLW, good to see you. Chicago 54. Crystal, we're going to start in about an hour. It's scheduled to start around 10 o'clock Eastern. Barry and Widespread Panic. Joanne Jedi Platypus, good morning to you guys. Welcome in, welcome in. Lisa, good to see you. Lemon Pound Cake, good morning and happy Friday to you. All right, let's see. I think I got everybody. Mel Stiller, good morning from rainy British Columbia. Becky B, good morning to you. Golden Girl, good morning. Thank you for watching. Appreciate that. 19 Marley Mum, you are number 97. Awesome. Oh, yeah, thank you. Thanks for reminding me. Yeah, hit that like button, you guys. Hit that like button as you come in. That reminded me to do it as well. Thank you for reminding me. Ruth Ann, good morning to you. Let me get caught up here. Camilla, there's the special D&D day. Let's see. Crystal, fixing to be a lawyer. Let's see. Yeah, the music is so Vander Ark. All right, let me catch up to you guys here. Kathy Davis, good to see you. JMS, you saw Sid with the new toy. Yeah. Hey, Debbie, good morning to you. All right. Edward, good morning to you. I think I got everybody. Crystal, Squeegee Vander Ark reminds me of Timothy Olson from Wisconsin. Bishop of Thunder, good morning from Allegan. Is it Allegan, Michigan? Is that how you pronounce it? Bite me. Awesome. Buttercup sends hugs and butter sugars. Nice. Denisha, good to see you. Lori, why is she back in court? She's asking for a new trial. She thinks she got ineffective counsel from Fred Johnson, and so she's asking for a new trial. Now, if you guys joined us yesterday, we showed her entire Ginther hearing from November 25th of 2025. So she wants a new trial because she thinks she got ineffective counsel. So what we're going to show today, we're going to wait for court to start. I thought we'd show her. Oops, sorry about that. I thought we would show her her actual trial. So this is her taking the stand during her actual trial. So, hey, Jenny G, good to see you. Case Unwinder, same question. Miss Bree, good morning to you. Oh, no, your emergency room with your mom. I hope all is okay. I hope all is okay, Miss Bree. Hope your mom is okay. All right, lemon pound cake. Yes, send anything that you have, you want us to look at, send it to our info@trialtvlive.com. Colleen, good to see you. Iowa Backyard, there you go. How are you guys doing? Lazy Boys, I hope I make some. Yes, we are planning. We are planning to make some lemon pound cake, and I'm going to film it and record it, and then I'll post it on my Cooking with Chris, even though it'll be baking, but it'll be cooking with Chris. Ionine, good to see you. Good morning, good morning. Let's see. I'm not seeing what lemon pound cake said. Hey, Betsy, good morning to you. Sean, yesterday was a great refresher. Yeah, thank you. Thank you for joining us on that. Let's see here. Anthony, there you are. Good morning. Thank you for joining us. Appreciate you coming in. Debbie, there you are. Your son passed away 20 years. I'm sorry. Mods need to bring you up. Well, we'll do our best. This trial isn't exactly the best happy trial, unfortunately. But sorry to hear that, and thank you for your food, your gifts yesterday, Debbie. We really appreciate that. Thank you so much, and I hope you can make it through today without too much heartache. I know it's tough, but hang in there. Just stay with us. You'll be fine. BFM Cookies, happy Friday to you, Lori. Good morning to you. So many of us have decided to make lemon pound cake. Yeah, no, it's going to be awesome. Hey, Bex, good to see you. Lori, hello, good morning, good morning. Let's see, couldn't tag Chris, but I know he has family in Ohio. Yes, we heard the big boom. Yes, it was the St. Patrick's Day meteor. And actually some fragments, it exploded pretty close to where my brother lives and his family. So, yeah, they said they were about 10 or 15 miles from where it exploded. Yeah, Sherry, no, we've been all over it. We've been talking about it. Mods and I have family. My niece said she teaches school, and she said her kids thought that Iran was bombing us. I mean, that's where they're at right now. My sister thought that a freight train had derailed. My brother said it was like this low thunder for like 20 seconds or something. Yeah, it was pretty intense. Pretty intense. So, hey, C. Gilmore, good to see you. You're welcome, Debbie. No problem. Just hang in there. It'll be okay. April 20th should be Afro Man Day. Should they make it? Oh, Ohio should make it a state holiday, or at least Adams County should make it a state, or make it a county holiday. So, all right. So while we wait for the live feed to kick in, we're going to let's watch her on the stand. So, all right, here she is. Here she is on the stand. This is from her trial. I think it was December of 20. Let me find out when exactly this was. Let's see. I know she was, her trial ended, her verdict was December 16th, and she was sentenced, 2023, and then she was sentenced January 23rd of 2024. So let me see when she actually testified, so I can get that for you guys. We'll get this date for you guys. All right, they're saying this was December 14th. All right, so this is her on the stand, and we'll do an Ego Takes the Stand with her. If you guys don't know, Ego Takes the Stand, that's one of our side streams where we take when a defendant takes the stand, thus the ego takes the stand. All right, so this is from December 4th. All right, this is from December 4th. Hey, Kathy, good to see you. Aussie Gardner, good morning. Stacy NYC, welcome in. All right, I think I got everything. Jennifer King, good morning to you. If I missed you, you forgive me. C. Gilmore, there you are. Golden Girl, I think I said hi to everybody. So forgive me if I did not say hello to you. Shadow, there you are. Angelique, okay, there's a few folks I missed. All right, Betsy loves hippos. All right. What was that one, Jessica the hippo? Betsy, are you familiar with Jessica the hippo? I think that was in Africa. We followed Jessica the hippo for a while. That was like 2009, 10, something like that. Hey, Mally. Yeah, Jessica the hippo is pretty interesting. All right. How's my audio? Is that, guys? All right, they're saying this was December 14th. Okay. Just want to make sure I'm not too loud. Hey, Lori. Good morning. All right. So this is Shanda. I'm pronouncing her name Shanda, not Shanda. Shanda. Shanda testifies December 14th of 2023. All right, we're going to watch this until the Ginther hearing kicks in, which is supposed to be around 10 o'clock Eastern, so we'll jump over to that when it comes in. All right, here we go.
All right, you may be seated. All right, Mr. Johnson, you can call your first witness.
Your Honor, the defense calls Shanda Vander Ark.
All right, Ms. Vander Ark, if you can come around here, please.
Stand in front of that chair. Raise your right hand, please.
Raise your right hand, please. In this matter now pending, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do, yes, sir.
All right, put your hand down, grab a seat. Please state your name for the record, spelling your first name and last name.
Shanda, S-H-A-N-D-A, Vander Ark, V-A-N-D-E-R, space, capital A-R-K.
Thank you, Ms. Vander Ark. You're being called to testify in your own cases. You understand that?
Yes, sir.
And to do that, you have to make sure that everyone can understand you, correct?
Yes, sir.
With you and knowing as I do, I don't think volume's going to be a problem with you.
Probably not, sir.
Talking fast, maybe.
Yes, sir, it might.
Okay, so this is, are you nervous?
Yes, sir.
This is stressful?
Yes, sir, very.
So you're going to be, questions going to be thrown at you fast and furious. You've seen how trials work, correct?
Yes, sir.
Okay. And under those circumstances, you may speed up again, as I do.
Yes, sir.
Okay. You may be reminded from time to time to slow down just a little bit. Do you understand that?
Yes, sir.
Okay. All right. Let's make sure everyone understands you. You've been sitting through this trial since the beginning, correct?
Yes, sir.
And you were arrested for these offenses alleged back when?
July 7th of 2022.
Okay. So you've been living with this thing for more than, what, 18 months?
17 months, yes, sir.
17 months. So you know what we're talking about, correct?
Yes, sir.
And you understand the allegations against you?
Yes, sir.
And that it also helps that you have a legal background, correct?
Yes, sir.
Okay. The things they said about how well you did in school and all those things, were those all true?
Yes, sir.
Okay, I don't want you sitting there and regaling this, but the things about cum laude and going to law school, all that stuff is true.
It was magna cum laude, yes, sir.
Okay, thank you. All right. Let's go back to the very beginning. When did Timothy come to your care?
May of 2021.
Prior to that, who had physical and legal custody of Timothy?
My ex-husband.
Okay. And when he sent, and how did it happen that you ended up with custody then?
My ex reached out to me stating that Timothy he could no longer handle him, that he was pushing his buttons, and that he needed to send him to live with me.
Okay. And you agreed to that?
Yes, sir.
Okay. Had you ever lived with Timothy during his...
When he was younger, yes, sir.
Okay. All right. So you agreed to accept him into your home?
Yes, sir.
And who was living in your home at the time?
Myself, my husband, Adam, Paul, Ferguson, and then my little man, G.
G. Okay, that's what we've been calling G, correct?
It's really hard to do, yes, sir.
Okay, just do the best you can. Okay, so they're all living in your home, and then Timothy joins you, correct?
Yes, sir.
When Timothy's joining you, did your ex-husband ever make any effort to transfer legal custody to you?
We discussed it, but he never did actually sign anything, no, sir.
Okay. And without legal custody, how do you get Timothy into school?
You can't.
And without legal custody, how do you get medical treatment for Timothy?
You can't.
Did your husband at least send his, I assume he had medical insurance for Timothy, did he send that?
He did not send me. I requested his medical card, his insurance card, and he never sent it to me.
Now, you heard the testimony that Timothy saw the doctor in 2019. Did you hear that?
Yes, I did.
That was a year before you received him?
2 years before I received him.
2 years before. So in the prior 2 years before you received him, as far as you know, based on what you heard here, your ex-husband never took him to the doctor?
As far as I know, yes, sir.
How do you know if he had medical insurance for this young man?
He told me he did.
Okay. But he never sent it to you?
No, sir.
Okay. What was your financial situation once Timothy arrived and your husband had a stroke?
After the stroke, we
Yes.
lost my husband's income, and it was paycheck to pay, not even paycheck to paycheck. Almost everything was paid late. I was struggling. I asked Paul for help with groceries sometimes because we were struggling.
Okay. And Paul was working full-time?
He was working part-time.
He's working at Applebee's?
Yes, sir.
Okay. So he's working part-time, and so were you receiving any child support?
No.
So the entire financial burden was on you?
Correct.
Could you have afforded daycare for any of your children?
Absolutely not, no.
And could you have afforded any extra expenses other than the ones that you were providing for?
No.
What type of expenses were you able to provide for this family?
Just basic living expenses.
Rent?
Yes, sir.
Utilities?
Yes, sir.
Food?
Yes, sir.
Okay, that leads to the next question I have for you. You had monitors and cameras in your home, is that correct?
Yes, sir.
And the impression from the testimony I heard is that it was for the sole purpose of ensuring that Timothy could not get the food. Is that accurate?
No.
Why did you have all those monitors and cameras in your home?
When Timothy came to live with us, his stepmother informed me that they had motion sensors. They weren't as tech savvy as I was. I worked in tech before law school. I worked in tech support for several years. But they had motion sensors and she told me that she didn't sleep at night. She only slept when he was at school because he was into everything. And so because my younger child, he used to, when he was about 2, he would take all his clothes off. So we started putting a camera in his room. And then once we moved to the Marshall Road location, it was bi-level. My husband was born with a disability. My husband was wheelchair bound. So we had an extra wheelchair that we kept on the upper level. That's where the master bedroom was. But that way, if G was down in his bedroom, my husband could talk to him through the camera and have him come up. It was much easier. My husband could crawl down the steps before the stroke, but we didn't want him to have to crawl up and down those steps.
Okay. And again, let's go back to the issue of food. Was food the only reason why you felt you had to monitor Timothy, or were there other issues?
There were plenty of issues, sir.
So, well, first of all, we've heard some testimony as to Timothy's special needs. What were his special needs?
He was on the autism spectrum, but he was completely verbal, and he was grade level in school. He was not behind in school at all. He was diagnosed with attention deficit hyperactivity disorder. He was diagnosed as bipolar and sensory processing disorder. I heard Paul mention physical disability. He didn't have any. Now, Timothy, when he first got there, said he had a physical disability, and I asked his stepmom about it to make sure, and she said no, he was not coordinated at all. The first summer that he lived with us, my youngest was playing baseball, and Timothy actually mentioned, because we had planned to put him in public high school, I'm going to try out for the baseball team, and I didn't say anything to him, but I remember thinking, sorry, sweetie, there's no way. You don't have the coordination for that.
All right. And he liked to take, well, you tell me, did he like to take things apart?
Oh, yes, absolutely.
Can you give some examples?
He took batteries apart. He took toys apart, my youngest son's toys. If he could get a hold of anything from Paul's room, he would take, mostly it was Legos. Paul still had Legos. He, at one point, messed with our water heater.
What do you mean?
He actually turned the gas off to the water heater. He knocked out the pilot light and then turned the gas off as well at different points.
Okay. Did you have any concerns as to whether or not his predilections, his desire to get into things, might be a safety hazard for either him or somebody else in the home?
I was extremely concerned about that, yes, sir.
So it was your desire to, was it just your desire to monitor Timothy, or did you also have a younger child in the home that you wanted to monitor?
We had both.
Okay. Was it, well, who did you want to monitor? One or the other, or both?
Both.
Okay. All right. So you set up these video and audio cameras, correct?
Yes, sir.
Okay. And alarms on the doors?
Those didn't get installed until about 3 weeks before he passed away.
Okay. And motion sensors?
Yes, sir.
Okay.
He got around the motion sensors multiple times.
Were you able to stay home and personally monitor your children?
No, I had to work full time.
Okay. How were you able to get Timothy into school?
No, we were not. We tried to enroll him in Mona Shores High School, and Mona Shores told me that my ex, I guess Timothy had damaged a Chromebook in Oklahoma, and because my ex owed money on that, they would not send his records up to us. So we were not able to enroll him. So I found online homeschool curriculum that I had to monitor, but I enrolled him in that.
Let me make sure I understand. Was it your original intention to put Timothy into public schools?
Yes, sir. We started the process. I filled out the paperwork. Because of my work schedule, I couldn't actually take paperwork to Mona Shores. My husband did that. Adam did that. But yes, we did try to get him enrolled.
Okay. And the youngest child, G, was he in public schools?
No, he was homeschooled.
What about Paul? Do you know if he was homeschooled, or if when he got to you, was he still in school?
No, he had graduated high school.
Okay. All right. Okay. Now, you mentioned that you weren't able to stay at home and care for your children at home, in the home, as a stay-home parent. Is that correct?
That's correct.
And what type of, I assume you're out working?
Yes, sir.
Okay. Explain to the jury the work that you did during the period of time that Timothy arrived in your home.
When he first arrived, I was still studying for the bar exam, so my husband was working full-time, and I was just doing, I trained dogs on the side, everything from basic obedience up through different types of service dogs for other people. And so I had a couple of dog training clients, but mostly I was studying for the bar exam. I also was an intern here in this courthouse.
That pay a lot of money?
Oh, it was not paid at all, sir.
Okay.
But it was the week of the bar exam. My judge that I worked for here as a law clerk informed me of this position that was open in Nuevo County, and she knew that the judge referred me, and that's when I did the interview, and I started work, I think it was 2 days after I completed the bar exam.
Okay. Was that a paid position?
Yes, it was.
Was it lucrative enough where you didn't have to do any other work?
Well, with my husband's income, it was.
Okay. But your husband's income stopped when he got sick?
When he had the stroke, yes.
Okay. So at that point, was it enough income to provide for you and your family?
No.
Were you receiving any other outside incomes?
My older brother lives in the home that I still own in Oklahoma, and he paid rent to us.
Okay.
But it wasn't a lot. That went towards our house rent.
Child support?
No. My ex, one of the siblings was forgotten yesterday. There's 5 total. We talked about the 4 boys. I also have a daughter. She is now 19, but she stayed down with her dad.
Okay.
So we each had one, so there was no child support. And because of child support on the other 4 kids, I actually was still paying my ex child support. It was still being deducted from my check.
Okay. So you had that's another deduction from your income?
$1,000 a month, yes,
okay.
sir.
So, were you also doing tutoring when you went to the judge who was paying you? Were you still tutoring or doing any other outside work?
Not at that. I was doing the dog training.
Okay. Let me ask you this. What time in the morning did you leave to go to work?
I usually left the house about 6:30.
And what time, on average, were you getting home?
About 6 o'clock.
Okay. So we're talking about 12 hours away from the home?
Yes, sir.
Okay. Those monitors, the video cameras in your home, you were able to view them while at work?
From my phone, occasionally, yes, sir.
Okay. But you were still working?
Yes, sir. I didn't view them at all until after the stroke. I mean, because my husband was there, or we had arrangements where my husband was off certain days of the week. Paul was off one day, specifically one day a week, so he took care of Gabriel and Timothy. And then the other 2 days that I needed care for Gabriel when my husband was working, he actually went to my in-laws' house down in West Olive.
May I approach the witness for just a moment, John? You may. You said Gabriel's age. Let's see. You have 3 children at home.
Yes, sir.
Okay. And my understanding is you faced other challenges personally in terms of your own personal health.
Yes, sir, I did.
Okay. For instance, let's run down the list. You had insomnia.
Severe insomnia caused by attention deficit hyperactivity disorder.
Okay. And for those folks who get a great night's sleep every night, don't understand what insomnia does to your ability to function, can you explain to them what impact chronic insomnia has on a person?
It limits your ability to think clearly. Your energy level is greatly reduced. Takes a lot longer to process things. You forget things easier. It was much harder to function with so little sleep.
Okay. And you talked about your other personal disorders. Were you receiving medications for those?
I was I have severe attention deficit hyperactivity disorder combined type. I also have sensory processing disorder and OCD. And then after my husband's stroke, as a result of my husband's stroke, because I viewed him, I wasn't in the room when he had the stroke, but I was there right afterwards. And so I developed post-traumatic stress disorder with disassociation from that. The only medication that I was on was for the ADHD.
Okay. And you had the service dogs in your presence too?
I had one service dog for me, yes,
Okay.
sir.
What sorts of interventions were available for Timothy's disorders?
When he came to us, he was on medication. They gave us a whole large gallon-sized Ziploc bag of medications for him. I could not refill them because I could not get him to the doctor. We were going to try to adjust his medication because when he came to live with us, when he took his medicine, he was a zombie. It was just horrific. And when Paul came to live with us, because Paul had only been there a year when Timothy moved up. Mm-hmm. And when he was on the same big bag of medication, and there were serious concerns that they just, instead of handling, especially my ex, he wanted to medicate them, but I never got that option because I couldn't take him to the doctor.
Okay. All right. There's been some allegation, there's been some implication, let's put it that way, that you tried to keep people from seeing Timothy, that you tried to keep him away from public view, that he didn't go to school, he didn't go to the doctor, etc. That he went outside, he was in the backyard. Do you remember that testimony?
Yes, sir.
If someone's outside in your backyard, are there trees or fences or other obstacles to keep the neighbors from looking over there and seeing who's out in your yard?
No, there was a clearing before. There was woods at the back of the lot, but there was a clearing, and at least the neighbors on each side, there were pretty sizable windows on the back of their homes. Mm-hmm. They weren't I think the next door was a 2-level, but the one on one side was just a single level. It may have had a basement, I don't know. But there was big windows, and they could see into our backyard easily.
Okay. Was it ever your intention to keep people from seeing Timothy? No,
my mother-in-law saw him. They do rental home inspections, I guess the city of Norton Shores. Mm-hmm. I don't remember if it was late April or early May of 2022, but it was in that neighborhood. And so we'd had the inspection that day, and my mother-in-law happened to stop by that day. And I invited her in. We sat and talked, and Timothy wanted to come say hi, so he came up and said hi to her.
Okay. Now, you're a Muskegon County transplant, correct?
Yes, I'm not from around here.
So, and I'm assuming that your direct biological family, there's not a lot of them in this county?
There's no, I don't have, other than my children, I don't have any biological family here.
Okay. Well, how far away are they?
My older brother is in Oklahoma City, and then I have 2 sisters that I have not talked to in over 20 years, and they live in Alabama, where I'm from.
Okay. So how often do those folks, your bio family, stop by and to see how sister's doing?
The last time I saw my older brother was when we went down to North Carolina for my oldest son's wedding in October of 2021, and then my brother and sister-in-law drove over from Oklahoma for the wedding as well. We FaceTimed a lot. We watched football games on FaceTime, but I didn't get to see them after we moved up here.
Okay. Do you have a lot of friends in the area that will come by, will stop by does it happen to be in the area, that sort of thing? They'll come by and visit your home?
Most of my friends were from work, and they actually, because I worked in Newaygo County, they lived in Newaygo or Oceana County, or even further. I don't know, I'm not from here. I don't know what county is next to Newaygo, east. But I know at least one person from work lived in, I think it's Big Rapids.
Yes.
So no, they didn't stop by because they were too far away.
Did you have a lot of time for social interactions at your home?
No, not at all.
And how about Paul? Did he have friends that he'd bring by, or?
No, he talked about people at work, but he never asked to bring anybody over.
Was he ever given any instructions? You can't have people in this house?
Absolutely not.
And what about the youngest child, G? Did he have any friends for sleepovers or anything like that?
We didn't have any friends over for it, no. He played baseball. Because of me not being able to get out, he didn't get out a lot. I mean, I wish I could have gotten him out more. That's why we put him in baseball, so he could get around other kids more. I had been looking into homeschool co-ops, but with my schedule, I just couldn't do that.
Okay. Which would you say was more impactful in terms of your, get Timothy out of the house? Was it your desire he not get out of the house, or your work requirements?
It was work requirements and his choice. There was, I want to say it was April. The weather was halfway decent. I guess people here there was kids down the street. There was teenagers playing basketball when I came home from the grocery store one weekend. Mm-hmm. And I stopped and rolled my window down and said, hey, I've got a 15-year-old at home. Can he come play with y'all? Even though I knew he wasn't coordinated, I thought he would enjoy it. And they said, yeah, sure, absolutely. And he did not want to go play.
Okay. Did he ever request to go play, and you denied him?
No, he never did. Actually, Paul, we had, Mom and Dad, my in-laws, got Timothy a bike for his 15th birthday. And Paul and we were on a cul-de-sac. And Paul had tried to teach him to ride the bike.
Okay.
I know they had a few sessions. I don't know how many.
Okay. So on those occasions, he'd be outside.
Oh yeah, he was out in front of the house in the cul-de-sac.
Okay. All right. Okay. Let's talk about some of the things that have come up in this case. There were leg irons discovered in your home. Were you aware of those?
I was aware that Paul had them. You actually could look on my Amazon. Paul had the option to do payment on the Amazon as well as mine, and Paul had actually ordered those under his account.
Okay. You did not order the leg irons?
I did not, no.
Did you ever use them?
No, sir. No, I never instructed.
Let's be in specific. Did you ever use them with Timothy?
No, sir.
Okay. Did you ever notice any bruising on Timothy's wrists or legs that might be attributable to the use of leg irons?
No, sir. I never saw anything like that.
You heard Paul talk about plastic ties. What was that about?
I honestly don't remember.
Okay.
I don't know why we would order. I mean, I saw the ties. I don't remember ordering them. I don't know what happened there.
You're going to say I don't remember a lot, aren't you?
Unfortunately, yes, because of the dissociation.
Okay. Explain to the jury what that means.
Well, I guess there's different forms. Somebody told me this. I did not find out about the PTSD and the disassociation until about 7 months after my husband's stroke, even though it had been going on since the stroke.
I need to place an objection on the record, and I think we're going to have to excuse the jury.
Okay. Please rise. We'll have to excuse you back to the jury room. Record reflect the jury is now in the jury room secure. Go ahead, Mr. Roberts.
Well, first and foremost, Your Honor, she's not qualified to testify about what disassociation means and what affects disassociation. Anything that she knows about that presumably would have been told to her by a doctor. We've already been down the road. Mr. Johnson's, to my knowledge, has tried multiple doctors that would be able to provide a diagnosis of Ms. Vander Ark to indicate that she has, some type of disassociation or some type of mental disorder which would have contributed to this offense, and has not done so. That's an insanity defense. We covered that extensively. Mr. Johnson, I think, valiantly tried to get that, and has been
See, that's good to remember. So she brings up this whole thing about disassociation in the Ginther hearing coming up. Just keep this in mind that they tried, meaning the defense tried, to call multiple doctors during her trial to testify on her behalf to say yes, she has, all these things that she claims that she has. They tried to bring that into trial, and no doctors were able to verify that. So keep that in mind if she brings that up in her Ginther hearing.
To provide any information to me from any medical doctor who's examined Ms. Vander Ark that she suffers from any of these diagnoses. So I'm objecting to this entire line of questioning about disassociation, about why she can't remember certain things. If she wants to say she just can't remember, I guess she can just say she can't remember, but she doesn't get to use the excuse that this is disassociation. Furthermore, I have a doctor still on standby as a potential rebuttal witness who did examine Ms. Vander Ark. It's the report from the Forensic Center, which Mr. Johnson has, which essentially debunks this entire disassociation myth that she doesn't remember things or chooses not to remember things because of some disassociation. So I'm objecting to this entire line of questioning. It's an inappropriate, essentially, defense that's being raised here. It sounds like it's almost like a diminished capacity type defense, which we all know is not a valid defense. And I'm not on notice of any insanity defense or any doctor would provide a diagnosis meaningful for the jury so they understand what these things actually mean.
All right, Mr. Johnson.
Thank you, sir. Initially, let me tell you what it's not. It's not an insanity defense. It is, and certainly my client can testify as to what she knows. Now, if the people are at liberty to examine her as to what she knows and how she might know that, and determine that her sources of information aren't adequate or that her understanding is inadequate. But certainly I can ask her what she knows and how what she knows corresponds to what's going on with her physically and mentally. Those do not rise to insanity defense, and certainly if she says, I don't remember, she can explain why. If she were a drunk and she said, I can't remember because I was drunk that night, we will allow that in. If she says, I can't remember because it's this dissociation thing, then that should be allowable. It doesn't rise to a legal defense. It doesn't rise to a argument of insanity. What it does is an explanation simply of what she did next. Why did you do this? Why did you do that? Why don't you remember these things? That's what this explains. And quite frankly, that I think is relevant, and is certainly, I think, permissible at this point. If the people have an expert that they can bring in and say, hey, look, that's not what's going on with this woman, that's their call. But to say she can't even talk about it because somebody else may disagree with her is not the standard. The standard here is the information relevant, and certainly, did she act upon it? Certainly. And she's acting upon this information, and does it explain an issue for which the jury has to determine. They have to determine intention. And quite frankly, if she doesn't even remember the conduct that she's involved with, certainly that goes to show that she didn't make I would argue that it shows that she didn't make an informed choice to do the things that happened in that household. But certainly she gets a chance to explain why it is, I don't remember, because that's going to be her answer. I don't remember. And so she gets a chance to explain that, and that's all we're asking here. We're not going to argue that this is a defense. It's just simply an explanation for why she did what she did.
All right, Mr. Roberts.
Well, she can certainly answer she doesn't remember. Absolutely, she can answer that. What she can't do is testify about a diagnosis that she says that she's been provided by somebody and an explanation for what that diagnosis means. She's not a doctor. Anything that she learned to talk about disassociation was provided to her by hearsay. And that those individuals, if that is going to be the testimony and disassociation is the defense, then I want the doctor here that examined her and diagnosed her with having disassociation so she can conveniently forget the horrible things that happened in this case. It's all hearsay. It's not the same thing as intoxication.
So, Mr. Johnson, I think you're going to ask her if she doesn't remember, assuming she's going to answer no. Well, why don't you not remember? She's going to say, well, because I have this dissociation disorder, right? I think you'd have to lay the foundation for that testimony, and the foundation for that testimony would be hearsay. Would be from some other source. She's obviously not a doctor. She can't self-diagnose herself. She's not been admitted as an expert, so she can, as a layperson, testify to what she feels and those things rationally based upon her feelings and what she sees and understands. So I don't think it's an objectionable. She can say, I don't remember. Why don't you remember? Well, because, I black out. Now, your example was drunk driving. Well, a layperson can say, hey, listen, in my experience, when I drink 8 beers, I, stumble, I can't really remember, those kind of things. And it's rationally based on her perception. And she can describe those things that are happening to her. I think that's fair. But in order to say, yes, that is exactly dissociation disorder or this, there's got to be a foundation laid for that.
Yes, sir.
And she cannot lay that foundation. And if she's going to, again, that would be hearsay. Again, if a doctor comes in and says, we told her this, that lays the foundation, okay, fine. But I think Mr. Roberts is correct when he says that foundation has not been laid, which would then implicate him bringing in a doctor to say that's not true. So based on that, I am going to sustain the objection. Again, you can still ask her about what she felt, what she heard, what she saw, the symptoms she experienced. I don't think you're objecting to that, Mr. Roberts. Is that correct?
Well, symptoms makes me a little bit nervous. I guess we can address it on a
Okay.
answer by answer basis.
But if she says, hey, look, I felt heart palpitations, or I felt my blood pressure going up, or I felt...
Oh, certainly talking about physical impacts on your own body. Sure, anybody can testify to those things.
Right.
But tying it to any specific diagnosis is just inappropriate because there's no foundation, as the court's indicated.
I agree. All right. So objection is sustained.
Do you understand? We can't talk about disassociation. We can't use that term.
Yes, sir.
Okay. Secondly, Judge, a few moments ago, I was given permission to approach my client. I whispered something in her ear. She was using Gabriel's name.
Yeah, Mr. John, I did hear that. Mr. Roberts caught that too. Yeah. So no, I didn't say anything then, and I understand.
Okay.
We've been, practice. I've seen you in practice. You haven't actually practiced in front of me yet, but I certainly have seen you in action. So I think I trust that you're not doing anything nefarious. So
Thank you, Your Honor.
Yeah. All right. Anything else, Mr. Roberts?
No, sir.
Okay. Let's bring him back out. Please rise. All right, you may be seated. All right, you may continue, Mr. Johnson.
Thank you. Ms. Vander Ark, you've told the jury about how busy you are, and you told the jury that you have some physical things going on with you, correct?
Yes, sir.
How did those things impact you in terms of your ability to think clearly, organize, and follow through on information?
Starting right after my husband's stroke, I started experiencing episodes where if you've ever passed out, like the world closes, you get tunnel vision and the world closes in on you until you completely black out. It felt like I was blacking out, but I didn't actually pass out. And the events that happened after that, I have no idea of what happened. I don't remember it. I don't know.
Okay.
And this happened anytime I got even a little stressed.
So you're understanding, you're under oath right now, correct?
Yes, sir.
And you're asked to tell the truth right now?
Yes, sir.
Okay. So we're asking you that you not guess at anything?
Correct.
Okay. Do you understand that?
Yes, sir.
So if you don't understand, we need to say you don't remember, we need to say those things?
Correct.
Okay. And you did testify that these symptoms and this pressure impacted your recollections, is that correct?
Absolutely, yes.
And then there's the final pressure. You're raising children and teenage children, some of them in your home at the same
Yes.
time. So all these things are going on at once, is that correct?
Yes, sir.
While you're at work monitoring, and you've got the ability to monitor the home, would your job permit you? Did you have the ability to sit in front of a monitor and watch the home all the time? Or were there times that you could not do that?
Most of the time I couldn't do it
And why is that?
because I had work to do. Part of the time I was in court with my judge, and then most of the time I was doing research or doing other tasks that my judge or one of the other judges in the county assigned. So I didn't have time to do that.
When you're watching the videos on the phone, you said you watched them with your telephone screen, correct?
Correct.
And it is a standard screen, nothing special about
It
it?
was an iPhone, I think it was a 12.
Okay. I've seen those video cameras systems where you can have 4 different cameras going all at one time, all the same screen. Was that your situation, or did you move from camera to camera and only have that camera visible?
No, the cameras were different brands and different cameras, so you could only do one at a time.
Okay, all right. So, and were you wearing an iWatch as well?
An Apple Watch, yes.
Apple Watch, thank you. Were you able to monitor your children from the Apple Watch?
No.
Okay. So If you were, say, in a courtroom like this and you're doing your job, you got a message on your Apple Watch, what would you get?
You could get messages and pictures. You couldn't see it. I mean, the screen was tiny, but you could get messages, and then there's certain like pat responses, like pre-programmed responses, or you can type with your finger.
Okay, I'm going to ask you about a specific email or text that you received that accompanied a picture. It's the one that the prosecutors given to the jury, that shows Timothy from the chest up and then his legs. You know what I'm talking about?
I have heard about it. I have not actually seen these pictures.
What you respond to it? How can that be?
I typed on we were in court that day. I actually think I responded. I'm in court. I scribbled out a message real quick back to Paul.
Okay. So did you see the photograph afterwards?
No, I had too many messages on my phone. I don't usually scroll back.
Okay. So how did you know to respond to Paul to say, give him some food?
Because of what he said. He had sent a message saying something.
Okay. So you were able to see the message?
Yes, I saw the and the picture. I mean, it's this big, but there was pictures. I just couldn't see what it was of.
Okay. I deviated again. I tend to do that. Sorry about that. I need to be more organized, and we'll get there. We talked about the leg irons. We talked about the plastic ties. And did you purchase those plastic ties?
I don't remember, honestly.
Okay. What about the hot sauce? Tell this jury about hot sauce and your son Timothy. Well, I'm not going to tell you my understanding because you don't need to know that. The question is, whose idea was it to get hot sauce and to administer it to your son?
The idea was originally Paul's.
Okay. And what was the point of the hot sauce?
Because we had tried multiple other discipline methods, and he thought maybe that would get him to stop misbehaving. Okay. He suggested it to me, and I was so wrung out, I was willing to try just about anything.
All right. Were you aware of Were you aware that this hot sauce was purchased online?
Yes.
Do you know why it was purchased online instead of going to Meijer and picking up a bottle of hot sauce?
Well, I didn't have time to go to the store. I mean, our groceries I did the grocery delivery through the Walmart app or through the Meijer app. And I didn't see anything. They just had basic stuff. And from our discussion, we had talked about something. And Timothy could handle this child. When I got pregnant.
I know you're going there. Well, hold on a second.
Okay, sorry.
I want to make sure we understand this. This hot sauce has a particular label. I've never seen it at Meijer. Did you see the label? Did you see the hot sauce itself? Did you order it?
I believe I ordered at least one of the bottles, yes.
Okay. Why did you order this particular hot sauce or these particular hot sauces? What do they have in common?
Because I think it was the same brand, the same one. Because it was hotter than what you could usually get, and because Timothy he liked spicy food.
Okay.
He loved spicy food.
All right. How do you know you like spicy food?
That actually started before he was ever born. Before I got pregnant with Timothy, I didn't like spicy at all. I mean, nothing, no heat, nothing. And when I got pregnant with him, I started craving. My ex liked spicy foods, but I didn't, and I started craving. Like I would outspice my ex. It was amazing. I still not to the extent when I was pregnant, but some of that remained. But Timothy, as early as age 2, he could eat a whole bag of the flaming hot Cheetos without a drink. I mean, just he could down. He loved spicy food. It was
okay.
It used to scare the heck out of me.
But you were aware that these spices were hotter than what you needed at Meijer?
Yes.
And it was for disciplinary issues. Is that correct? Did you ever? The testimony was that you did child care while Paul was at school or at work. Did you ever administer any of the hot sauce yourself?
If I remember, I might have done some on bread a couple of times.
Okay.
But usually by the time I got home, that either we were cooking food, I had to cook, or I had Paul cook something so I could feed everybody. But I don't recall. I think I did it on bread once or twice maybe, but that was it.
There's a text out there that says you suggested putting hot sauce on his penis. Do you remember hearing that with the jury?
I remember hearing it, yes.
Do you remember saying those things?
I do not, no, sir.
Oh yeah, we talked about the ice baths. Some talk cold baths, and sometimes they were called ice baths. Do you remember that testimony?
Yes, sir.
Okay. The source of the ice, according to the testimony I heard, was your home refrigerator.
No, it was actually a countertop ice maker. The refrigerator did not have an ice maker in it.
Okay, and you didn't go out and buy the 50-pound bags of ice for the home.
No, I did not.
How much ice are we talking about that tabletop ice maker can?
It actually made about a cup and a half of ice. I had to measure it to use it for, I made some frappes at times.
Okay.
The basket was maybe this wide, and then underneath was the water, where the water was kept, because that's how it made the ice.
Okay.
And then it took about 2 hours to remake more ice.
Okay. All right. Okay. You admit getting frustrated with your child care efforts with Timothy, is that correct?
Yes, sir. Frustrated, discouraged.
Did you ever intend to hurt him?
No, absolutely not. Absolutely not.
You raised other children, correct?
Yes, I did.
And while Timmy was malnourished, to your knowledge, have any of your other children ever been reported as malnourished?
No, not at all.
As I looked at Paul, he seemed like a thin guy to me.
He is. We're all pretty small. Well,
Okay.
my oldest is a little bit thicker.
Okay. My question is this: was Timothy's, when he was healthy, was his build like his brother's, or was he built like his older brother, who was a little heavier?
He went back and forth. He actually, there was a situation where he actually got on the bathroom scale it was after Mother's Day of 2022. I can tell you why I know it's after Mother's Day if you want me to.
No, that's not necessary.
Okay.
Unless you
But
ask.
I was training a new service dog, as has been discussed. It's a Great Dane puppy. He was 7 months old at the time, and he was too big to sit on the bathroom scale to get his weight, and I wanted to see what he weighed. And Timothy, what we would do is somebody would stand on the scale, get your weight, and then you pick up the dog. And Timothy wanted to help out that day. So I thought the dog would be too big for him at that point. He was already really big at 7 months old. But I said, okay, let's try it. And so it was, like I said, sometime after Mother's Day. It wasn't very long after Mother's Day, but at the time he was 104. Timothy was. Okay. He could not pick up the dog because the dog was 102 at the time.
Okay. Part of this process of providing child care, somebody had to be the eyes in the house when you weren't there, is that correct?
Yes.
And you selected Paul for that purpose?
I didn't have a choice. That was my only option.
Okay. How much did you rely upon what Paul was telling you?
I totally relied on him.
Do you remember during the reading of the transcripts, the text, that you asked Paul? Matter of fact, let me... Be honest with me. Are you worried about him at all, or is it all a bunch of BS like it has been for days? Do you remember that? Do you remember that text?
Vaguely, yes, sir.
Okay. Do you remember his response?
I remember he said he wasn't worried about it.
Okay. Did you rely on that?
Yes, absolutely. He was the one. I was at home so few hours when the kids were awake, unfortunately.
And then you had to try to sleep yourself.
I tried, yes, sir.
And
they slept better than I did.
Let's face it, your house is a mess. It's a wreck.
Yes, sir.
Why was that?
I'm not a great person at keeping things clean, and having 3 boys, that contributed. I tried to get their help cleaning up as much as I could, but I just didn't have time or the energy. With the lack of sleep and everything else going on, I barely functioned.
Okay. And that message, strike that. I don't need that. Did you depend? I asked you. Did you depend on what Paul was telling you?
Yes, sir.
So in your opinion, did Paul ever, for lack of a better term, sound the alarm?
Not that I was aware of, no, sir.
Okay. That one message, was that it?
That was it. That's the only thing I got from Paul that ever had any concern.
With one little pictures in it, correct?
Yes, sir.
Okay. And okay, let's talk about some other stuff here. Once you discovered that Timothy had passed, and once the police get there, do you tell them the truth?
No. I was so freaked out. I'm sorry. Honestly, I've got one. I'm sorry. Thank you.
You're welcome. Why didn't you tell him the truth? Why were you so freaked?
I don't remember what my line of thinking was at the time. I was so tired. I don't know. I wish I had an answer for you, but I don't.
Were you tired at that point?
I was exhausted. The night before he passed, I had less than an hour of sleep.
Were you frightened at that point?
Absolutely. I just lost my son.
You need a moment?
I'm okay.
Okay. Were you expecting? Was this outcome expected by you?
Absolutely not. No.
So would it be safe to say you were surprised?
I was shocked.
Were you in disbelief initially?
Yes, absolutely.
We've got there's an indication that it took you a while to call the police. In fact, you told Paul not to, according to Paul's testimony. Why did it take you so long? He said 18 minutes. I don't know. Why did it take you so long to call the police?
I have no idea, honestly. I'm trying to figure out how to describe it. It was surreal. Like you don't even know what's going on. Time slowed down and I didn't know what was going on.
When was the first time you found out it took 18 minutes to call the police?
Was it yesterday or the day before? Yeah, it was within the last few days.
Okay.
That's the first time.
Do you remember who was testifying when you found out? It doesn't matter.
I think we discussed it at a meeting on Monday. Was it Monday?
Okay.
I think so.
Doesn't matter.
And I heard 14 minutes initially, and then the first time I heard 18 minutes was when Paul said it yesterday.
Do you remember? How clear is your memory of your time and from the time you found Timothy and he had passed, and to the time you finished talking to the police that day?
It's spotty.
Okay. The first officer said that you were distraught. Do you agree with that?
Absolutely.
He said that you were crying. Do you agree with that?
Yes, sir.
Do you remember telling the police that you pulled Timothy from his bunk bed when you found him in distress?
I remember saying something like that, yes, sir.
Was that true?
No, sir.
Do you remember providing CPR for Timothy?
Yes, I do.
When did you stop that?
When the pro-med people walked down into the basement. I had asked them to take over, and they didn't take over right away, but they said I had to leave the area.
Okay. Let's do the hard stuff here. Jury's seen pictures of Timothy. We've all seen pictures of Timothy at the time of his death. How could you not know he was that ill? How could you not know?
Honestly, I was barely functioning. I missed a lot. I hate it because, I feel like a complete failure, but there was things that I just didn't see. There was a lot that I didn't see, unfortunately. In those texts, you instruct Paul to make sure he's getting enough calories, correct? Yes, sir. I did.
You had a restricted diet, correct?
Yes, sir.
But you instructed Paul to make sure he's getting calories.
Yes, sir, I did.
Did you rely on that?
Absolutely.
Paul says he called the police ultimately. Who called the police?
I called 911. It was on my phone. I'm sure you can pull the call and find out where it's from.
Did you intend to hurt Timothy?
No, never.
Did you know he was being hurt?
No, I didn't, unfortunately.
The tactics that you use to first of all, the tactics that you use to discipline Timothy, Did they seem extreme or outrageous to you at the time?
No.
Timothy remained in, you'll admit the bath was not warm on the day he died. It was a cold bath.
Correct, the day before.
It wasn't an ice bath though, correct?
I
As far as
wasn't.
you know.
From the text, it looks like he did, but that wasn't what was said to do.
Okay.
Paul chose to do the ice on his own. If you look at the text.
Okay. So, there's testimony that you remained in that tub for hours. Were you aware of that?
No, I didn't realize he was in the tub. No.
When you came home, you didn't realize he was in the tub?
I did when I got home. I actually ran him a warm bath when I got home.
Okay. Where?
In the tub downstairs.
Okay. So, once you found him in the tub, what did you explain the dream? What you're talking about?
Well, I had to get Paul to work, and then I came home and
Get in there. Hold on. All right. All right, you guys. So we have a live feed. Feed is kicked in. But before I do that, I know you guys have been asking about Roger. So he had us up until 2 last night, but he's here. He's relaxing. So he gets to go back to sleep. We get to show you Shanda. Shanda. All right, here we go. Let me just get myself set up here, you guys. All right. All right, here we go. No longer replay. We are live. All right, here we go. No audio yet. His braids for the witness stand. Yeah, she likes to do her Dorothy. She does her best Dorothy impression. So no audio yet. So just hang in there. Let me turn myself up. All right, sorry guys. Yeah, so no audio yet. She looks okay, right? She looks healthy. She doesn't look like she's sick. Although she generally has that puss on her face. Let's see if she what kind of shenanigans is she going to pull? What kind of shenanigans will Miss Vander Ark pull today? Tony, wonder who her hairstylist is? TM, your cat is a princess too? Yeah, I think we treat our pets and just animals in general way better than she treated Timothy, that's for sure. I'm just wondering who else is going to testify. I'm wondering who else is going to testify. Because we had Mr. Johnson, we had the two of the people that transported her, but that was just specifically because she was sick. There was another woman that testified. I forget her name. I think she heard something that Shanda was saying something about self-deletion. All right, let's get some audio here. Where's my audio? Here we go. All right, here we go.
Before the court is filed 2023-110-FC with the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? Yes. All right, Ms. Vander Ark appears before the court with her attorney, Mr. Ronald Ambrose. Ms. Bloomquist is here on behalf of the people of the state of Michigan. Setting time for a continuation of a hearing on a defendant's motion for a new trial. I believe we are at the point where Ms. Vander Ark was going to testify. Is that correct, Mr. Ambrose?
It is, Your Honor.
Okay, is that your understanding, Ms. Bloomquist?
That is, Your Honor. At the last hearing, we took some of my witnesses out of order so that we could just kind of get something done on the record. I believe it was November 25th.
Yep. Okay, all right, Mr. Ambrose, you can go ahead and call your first witness.
Yes, Shanda Vander Ark.
All right, Ms. Vander Ark, if you want to come right around here, please remain standing and raise your right hand. For the record, spelling your first name and last name.
Shanda Vander Ark, SHANDAVANDER, space capital ARK.
Okay, go ahead, Mr. Ambrose.
And Ms. Vander Ark, you are the defendant in this case, is that correct?
Yes, sir.
And your attorney at the trial court level was who?
Fred Johnson.
Fred Johnson. And when did you first meet with Fred Johnson?
About the case, the day after, 2 days after I was arrested.
Okay. And can you tell the court what your conversations were with Mr. Johnson?
That first day, we just kind of talked in general. We said from day one that I was going to have to testify. So we talked about that. He talked about he was putting together a team to work on it. And I remember one thing of all the weird things to remember. He asked me what my favorite TV show was, and he was going to have an intern watch it and then come in and tell me about it every week, just to have that time. But there wasn't a whole lot of specifics that day. We were just talking. He asked about my mental health. And
was there any a point in time that you ever conceded your guilt in this case?
never.
Did you always relay to Mr. Johnson that you were not guilty?
Yes.
All right. Have you ever been charged with anything?
No. I've never even gotten a parking ticket.
Okay. You have testified in this case, correct?
Yes, sir.
Prior to testifying in this case, had you ever testified before?
Yes, sir, when I was a kid.
Or how old were you?
Oh gosh, from age 8 up through, I think about 16 was the last time my biological father tried to get visitation or custody of us.
Okay. Was being charged in this case, can you describe your mental health immediately after being charged, I guess?
Oh, horrible. I couldn't eat, I couldn't sleep. I actually didn't eat for 18 days after I got to Muskegon County Jail. It was, I didn't know which way was up.
Just as a bit of a background, when did you move to Michigan?
Oh gosh, 2015, I think.
Okay, and
My little guy was like 6 months old.
Okay, so it was, who moved to Michigan with you?
It was my late husband Adam and little man and myself. That was it.
Okay, and at some point Paul comes to Michigan?
Yes.
Do you recall when that was?
He had just turned 18 and graduated high school, so that was 2020. It was in the middle of COVID.
Okay, and sometime after that Timothy arrives?
A year later.
Do you remember the month?
I want to say it was the end of May because school had let out.
Okay. May of 2021?
Yes, sir.
And I think during your testimony in this trial, he came with like a bag of medications.
A gallon-sized Ziploc bag, yeah.
All right. What were the medications for?
Well, he was diagnosed ADHD, sensory processing disorder, bipolar, and on the autism spectrum, but he was very high functioning. And so that was, he had, I don't remember the name of any of them really, but there was one that made him like a zombie that he took twice a day. And I mean, I think there was probably 8 or 9 medications per day that he was taking.
Why did he move to Michigan?
I got a text from his dad one day that he could no longer deal with him, that Timothy was pushing his buttons, that if he did not come to live with me, my ex was going to put his hands on him.
And so in May of...
And asked me to take him, yes, and I took him.
From May and when he first arrived, what was his behavior like?
I mean, he was about to turn 15 when we got him, so he was a teenager, but nothing outlandish. I mean, he was trying. He did not care to tell the truth hardly at all. There's no point in asking him a question pretty much the whole time. But you know, he would do stuff. He took my youngest toys at times. He broke a couple of them, and then he took some stuff from Paul. But like, it was just typical teenage. It wasn't anything that we couldn't handle. So.
In January of 2022, a significant event happens.
My late husband Adam had a stroke January 3rd of 2022.
Okay.
A massive stroke.
And how did that impact the household?
Better question is probably how didn't it? I lost his income. I was already the primary breadwinner, but then I'm the sole breadwinner. We had a babysitting schedule worked out for the little guy, and with Paul and Timothy, at that point we didn't leave Timothy alone with the little one, really. And you know, I was working full time. I was gone because of the location I worked and driving over there and driving back. I was gone from the house 12 hours a day, 5 days a week. So everything just fell apart.
Timothy being watched by your late husband prior to January?
Yes, yeah, him and the little guy. And Paul.
I think you mentioned that in your direct testimony, this was around Mother's Day of 2022. Timothy was about 104 pounds.
Mm-hmm.
Is that a yes?
Yes.
And you knew that because he picked up the dog.
He weighed the dog. I could no longer lift it. It was a Great Dane puppy that was 6 months old at the time. And the dog weighed 102 pounds. There was no way I could lift that dog.
Okay.
And so he got on the scale, weighed himself, grabbed the dog, got on the scale.
What happens from that day until July 6, 2022?
I mean, from what little I remember, it was the same thing that had started when the stroke happened. Timothy, I remember a couple times, he flat out told me, he said, I'm going to keep doing stuff until you just let me do what I want. And I said, that's not happening. And it just snowballed. I don't remember a peaceful moment after the stroke for one reason or another. And that's not all on him. I mean, it was just in general, but he certainly created a lot of it.
He dies on July 6, 2022, correct?
A month before he's 16.
When are you arrested?
July 7th.
And are you immediately taken to the Muskegon County Jail?
You mean on the 7th?
Yes.
Yes, from the Norton Shores Police Department.
Okay. What were your conditions like in the Macomb County Jail, or Muskegon County Jail?
It was awful. I was on max security solely because of my charges, so I was isolated completely by myself in a room.
When you say max security, what was it like?
You're in a room by yourself. You only have the option of getting out of the room into the pod 1 hour a day, so you're locked down 23 hours a day. For me, I was in such bad shape. I couldn't eat. I barely slept. I mean, the whole 17 and a half months there, I might have averaged an hour or two of sleep a night. And there was no mental health treatment. I mean, they tried a couple of meds, but they did nothing. And I kept asking to speak with the doctor, because it was always a social worker. And she said, oh, you're on the waiting list. And I guess the waiting list was longer than 17 and a half months. But I met with her a few times, and she was no help at all. She'd say, oh,
Because of anything that you did, it was just the nature of your charges that they put you in max?
That's the only reason, yes.
How often, well, did you have mental health issues prior to that?
I have severe ADHD and I have sensory processing disorder and a little bit of OCD. I guess it was a month after I got to Huron Valley, I was diagnosed bipolar, which I've had my whole life, I guess, and didn't know it. But at the time, I just knew about the ADHD and the sensory processing.
How often during this time period would you see Mr. Johnson? From the time that you're incarcerated to?
I think the first month I saw him 2 or 3 times, but after that it was every once in a blue moon. I think he said it was once every other month. It didn't even seem like that often.
During your conversations with him, were you talking trial strategy?
A little bit. We didn't a lot, but we did a little bit.
Was it ever, well, tell me what the strategy was.
Well, on the child abuse charge, it was intentionally and knowingly, and that was, without that, the felony murder charge was gone. And so that's where we focused. It was never on I didn't even realize second degree would be an option until the day of jury selection. So we focused on the intentionally and knowingly from that, because that cost the felony murder charge.
Did you know manslaughter was
He never,
an option?
we never talked about second degree or manslaughter until the day of jury selection. It was on the jury instructions for second degree. And then the last morning, when I had the breakdown, I vaguely remember him coming in and saying he got these instructions added. And I had no clue what to say. I was in bad shape, so.
Well, tell me about, I mean, you testified,
Yes.
and tell the court how you felt during your testimony.
Well, before the testimony started, and this was one of the things that really shocked me, while the medical examiner was testifying, Fred was writing down questions. He had not had any
Objection,
questions.
non-responsive.
Sustained.
How were you feeling during your testimony?
Stressed, panicked, scared, terrified.
Okay. And after, how did your testimony end on that third day of trial?
I believe they were talking about jury questions, and I had a really bad panic attack. Well, I had been in the room by myself in a pod.
Well, I mean, from the time that you leave the courtroom, this courtroom.
Yeah. Instead of going back to the pod, I guess the sheriff had decided to put me back down in holding instead of where I had been, where there was at least people around, even though I couldn't come out to see them.
Are you okay, so you're talking about in this
In Muskegon
building?
County Jail, yeah.
Oh, at the building, okay.
Yeah. So he separated me completely down in holding, and
Did Mr. Johnson talk to you after that, on that third day?
no.
Okay. And what happens at the jail over the course of the night?
Well, I remember right after I got back, I mean, I was upset at the whole being separated, holding, the lights don't dim, the noise level was horrible, and I was trying to think through trial stuff just to keep myself occupied. I had thought of some questions I wanted him to come back and try to ask me the next day, but then I might have, I don't know if I even slept for an hour that night, but I remember that when I was, I don't want to say come to, when I was functioning, I was curled in a ball. I was freaking the heck out. I couldn't, when they first came to get me, I said, I can't even go. I can't leave the room. And they're like, well, you have to, come on. And it just.
How were you taken from the jail to the courthouse? Or courtroom?
Well, we went to, I guess, where I changed clothes, and that's as far as I got. We walked over there.
Okay. We heard, you were in the courtroom when we heard some testimony that you were curled up in a ball. Is that accurate?
Yes.
Were you suicidal?
I don't remember saying it, but yes, apparently I made at least one comment that I was going to kill myself.
All right. I mean, it sounds pretty drastic. What else do you remember from that morning?
I remember just being sheer panic. I was frozen, like I couldn't even move. I remember laying up against the wall on the floor on my side on one of the concrete benches in one of the holding rooms that they tried to come upstairs, and I couldn't do it. And so I went in there and curled up in a ball on my side. I was completely paralyzed. My brain was not working. Anytime I even thought about anything, I wanted to panic, and I had several panic attacks during that time.
Do you recall talking with Mr. Johnson during this time?
A little bit, yes, sir.
What was the nature of your conversation? Or was he talking to you? Are you talking back?
To get the involuntary manslaughter instructions put on, and I remember thinking, what's that got to do with anything? And then I specifically asked him, after we tried to come upstairs, I said, look, can we please adjourn this? I can't do this today. And I asked him several times, and he made a comment. He said, oh, it'll just be the same way if we do that. You're gonna have the same issue. And then he said, well, we'll just go on without you, and then he left.
Do you recall signing the document?
No.
You've seen it since, though?
Yes, I have.
All right. Is that your signature or not?
I mean, it looks like it. It looks like a version of it.
Okay. But you don't recall signing? Is that a no?
No, sorry.
Did any medical personnel come to talk to you when you were in your condition?
No, sir.
When you were testifying on that third day, did you ever concede that you were guilty of anything?
No, not for a second.
And as far as you knew, Mr. Johnson knew what your position was.
Oh, yes.
And what was that?
That I was not guilty. We had a visit. It was one of the last couple of visits I had with him, and he was actually the one that stated, we've been talking about the intentionally and knowingly, and he said, they don't have intentionally and knowingly, you're not guilty.
Okay.
And I clung to that.
And the intentionally and knowingly phrase that relates to the first degree child
Yes, sir.
abuse. And in your understanding, the ultimate charge was felony murder.
Yes, sir.
And the predicate offense was the first degree child.
Yes, sir.
All right. I don't have any further questions now.
Is it all right if I move the podium? Good morning. So, Ms. Vander Ark, I just want to go back and ask you a little bit about your background, okay? So, were you a legal clerk, or what was your exact role at Newaygo County Circuit Court?
I was a law clerk.
Okay. And you were previously an intern in Muskegon County Circuit Court, correct?
I was, yes.
What were some of your job duties in those two positions?
Oh, sorry. Well, both of them. I did legal research about the extent of it here, because I was still in law school. When I worked for my judge in Newaygo, I actually did the research, and I would draft opinions, and then he would, decide if that was okay, and then most of the time he just signed off on that I'd gotten it correct.
Is it fair to say that you worked on post-conviction motions for your judges,
Yes, I did several times.
including claims of ineffective assistance of counsel?
I would assume so. I don't remember.
And so in other defendants' cases, you would be writing draft opinions or bench memos for circuit court judges.
That's what I wrote. I don't think we had an ineffective assistance. I don't think so. I may be wrong, but I don't think so.
And it's your testimony that your opinions or your recommendation to the judge was so good, he just wrote off on it, signed on?
On most of the time. There was a few that he adjusted, but he would read them and then send them over to his clerk to publish. So.
And this all happened before you were criminally charged, correct?
Yes.
So even before you were at a trial, you are intimately familiar with post-conviction motions, correct?
I wouldn't say intimately familiar. I mean, some of them I was familiar with, but
Familiar enough for your judge to just rubber stamp what you
for
said?
the ones, a lot of what we did, actually most of what we did was civil. There was some criminal, but most of the motions and the work I did as far as writing was civil. He did both civil and criminal.
Now, Ms. Vander Ark, you mentioned that Mr. Johnson had a team of individuals at the Public Defender's Office, correct?
Yes.
And could you tell the judge how many individuals were on that team?
I have no idea. I think total I met with, over time, probably 6. And then I know he mentioned having somebody doing research and other people and other interns working on it, but that's the people I met with. I don't know how many there were.
Okay. It wasn't just you and Mr. Johnson working on the case, though?
No, it wasn't.
He had social workers that
Yes.
assisted you?
Yes.
And it sounds like interns as well?
Yes.
And other attorneys in his office?
Yes, I only met, as far as the criminal side, I only met with another attorney in his office. It was at one hearing, it was the gentleman that sat second chair, and then at trial. I didn't meet with any of the other attorneys otherwise.
And you said that Mr. Johnson began meeting with you approximately 2 days after your arrest.
Yes.
And he continued to meet with you throughout the pendency of the case?
Yes.
And his team would meet with you throughout the pendency of the case?
The social worker is the one I saw the most. I'm trying to think. I saw the intern some, but that was...
Do you recall, was that Melinda Katecki?
For the last 2 visits, I only saw her twice in person. And I think she was online once for a meeting with a doctor. But there was another social worker that met with me once a week, usually for the first few months. First, I don't know, probably 6 months at least, and then she moved on from the office.
Now, Ms. Vander Ark, you've spoken quite a bit this morning about your medical, I guess, episode, for lack of a better term, medical episode that happened mid-trial. Okay, so I'm going to go into that. But that's not the first episode you had during these proceedings, correct?
No.
Okay. And one of those happened at your preliminary hearing, or your preliminary examination, correct?
Yes.
And that occurred just before Paul was going to testify at the prelim, correct?
I believe so.
And your medical episode that happened in the trial happened right when you'd been confronted during cross-examination, correct?
I had one other one before, during trial.
Okay, when was that?
There were some police officers testifying.
And it's
But I was sitting there and had a panic attack, and they cleared the jury out.
And do you recall what the officer was testifying about when you had that
I don't.
episode?
No, I don't.
Probably something pretty significant about your case, though, correct?
I mean, I would assume so.
Or something about your son's condition?
I don't know.
It's fair to say that those episodes, though, don't happen all the time.
They do, well, they were beforehand, and they still do happen consistently.
That's a poorly worded question, so I'll clarify here. Those episodes didn't happen on direct examination with your own attorney questioning you, correct?
They didn't happen yet?
They didn't happen during opening statements?
No.
Or jury selection? No?
No.
They didn't happen during certain parts of your preliminary examination?
No.
But these episodes happen when you're confronted with evidence that you don't want to acknowledge or admit. Is that fair?
No, they happen when I was confronted with traumatic events. It was anything traumatic that got that bad.
So seeing your son, who was in your care for all those months, in a picture, was traumatic to you?
Yes, extremely.
But you'd seen him every day that he was in your care, correct?
Yes. What I remembered, yes.
And then when you see a picture of him on that stand is when you have this episode.
Yes, I mean, I had panic attacks. Looking back, I know I had panic attacks previously, but I don't know what brought those on.
Nobody diagnosed you with a panic attack on the night of that trial, correct?
I don't know.
That's a yes or no?
I said I don't know.
Okay. You have no evidence that you had medical diagnosis of a panic attack? that day?
That day? No. As far as I know, no.
And you have no medical diagnosis that you had a panic attack during your preliminary examination, correct?
There was no medical person called in.
Okay, so my question was, you don't have medical documentation of a panic attack that day?
No.
So let's talk about some medical documentation you do have. You recall Mr. Johnson submitted you to multiple individuals for forensic examination,
Yes.
and you met with those medical providers?
Yes.
And how many would you say, based on your memory, you met with?
A couple?
Okay. Would it surprise you that there's approximately 4 reports regarding your criminal responsibility or competency?
No. It
Would it surprise you?
No, because I understand the process, so it doesn't surprise me.
Okay. What's your understanding of the process?
That both sides can get the competency evaluation and the responsibility evaluation.
And you understand that under Michigan law, you're presumed competent unless proven otherwise, or unless shown otherwise, correct?
Yes.
Okay. You've never been shown to be incompetent, correct?
Not medically, no.
No, not legally. Is that correct?
Yeah.
You have never had a legal determination that you are incompetent, correct?
Yeah.
And that's after meeting with these 4 providers, correct?
Yes.
And in fact, some of the providers called into question your rendition of facts to present to them. Do you recall that?
I don't recall that, but I'll trust if they said that.
Do you recall specifically, let me go back here before we get into that. Do you remember your interviews with these providers?
Bits and pieces.
Do you feel that you were truthful with them?
Yes.
Do you feel that you appropriately explained your situation and your memory with them?
I hope so.
But you don't know, correct?
No, I don't.
Bear with me one moment, please. Your Honor, I'm referencing People's Exhibit 2, which I believe was attached to my brief, which would be a June 20th, 2023 report authored by a Benjamin La Liberty, doctor. Now, did you tell this doctor or this individual at the Department of Health and Human Services Center for Forensic Psychiatry that you disassociated during times that Timothy was in your care?
Yes, even times when he wasn't. I mean, it happened regularly, it still does.
Well, and that's my question. So, is your claim in this post-conviction motion that you were disassociating during parts of the trial?
I mean, I'm not a medical person, so I don't know, but that's the only answer I have.
Well, so I'm not asking you to give me a medical opinion. I'm asking you to tell me what you mean when you're saying you disassociate. So what do you mean when you say you disassociate?
Usually it's a panic attack, and I have no clue what's going on around me. I don't remember anything during that.
And when you've said that on that day of trial, when you had your episode, that you had a panic attack. But would that be a disassociation like you have just described?
During the panic attack, yes. They usually only last like 10, maybe 15 minutes.
Oh, okay. Yes.
I just want to interject. Ms. Vander Ark, can you describe to the court what you believe and what you are experiencing? So what do you call panic attack? What are you experiencing during
this event that you label as a panic attack?
It's one of two things on the breathing. Either I hyperventilate or I feel like I've got an elephant sitting in my chest and crushing it and I can't breathe.
So that's trouble breathing?
Yes. I'm shaking. My head is totally spinning.
So dizziness?
Yes, sir. I don't have a clue what's going on around me. I know people have tried to touch me during a panic attack, and that just freaks me out worse.
You mean painful?
No, just trying to make sure I'm okay.
So when somebody touches you, what do you experience when somebody touches you?
I pull away, and the panic gets worse.
Okay, so you're aware of somebody touching you. Is it you have auditory problems where you can't hear, or you just have an inability to understand what's being said?
I think it's both. I mean, I don't remember anything that's been said to me during a panic attack. I know I had a couple people scare me at Huron Valley. They were just playing around, but it caused a panic attack because I didn't know they were there. And I guess they tried to talk to me, and they said, yeah, we got no response, and I don't remember them trying to talk to me at all.
Okay.
It's like I'm down
Any other symptoms?
It's like I go into a total darkness, like this black hole.
No. When you say darkness, are you seeing black? What are you seeing? Is it
Like a
spots?
black or gray, usually. I'll try to fix on a spot as it sets in, but then that's it. I don't see anything else.
Can you move? Are you able to move your arms, legs, extremities?
Not most of the time, no. I'll curl up into a ball and
So let me ask you a question. You curl in a ball, you consciously make the decision to curl into a ball to stop the symptoms? Or is it an involuntary movement into a ball?
it's an involuntary movement.
So involuntary movement into a ball. And then you don't know how much time passes?
No,
Is that what you're telling me? Okay.
no. I know that afterwards, I've had somebody there and look at the clock, and the only thing I could tell you I've had people say anywhere from 10 to 15 minutes that were around.
And you said these have happened while incarcerated currently?
Yes. They still happen
In
regularly.
your cell, in the common areas, where they happen?
Most of the time it's in my room
In your cell?
or in the restroom, yeah.
Room or restroom? Okay. Any times when other inmates were around?
Yes,
Okay. So common areas?
yes,
And you're aware that these areas are filled, correct?
yes,
This would be on camera.
yep,
Okay, so you're telling me that you experienced a panic attack where you curled in a ball on camera at the prison.
yes. In the foyer of one of my units, somebody came up behind me and scared me, and
Do you know approximately when that was?
I have well, I can give you a date range because there's a certain time I was in that unit.
Please
It
do
would
so.
be somewhere between end of August of 24, and beginning of January of 2025.
Okay.
That was the time I was in that.
All right, thank you. I just want to make sure we understand each other about panics. Go ahead, Ms. Blue.
Let me clarify, you said August of 2024 through January of 2025?
Yes, I was in. I can give you the name of the unit if
Yes,
you want.
that would be helpful.
Gladwin A.
So, Ms. Vander Ark, now it seems like we're all on the same page about what you mean when you say panic or disassociate.
Yes.
Okay. And it's fair to say it's your testimony that you had that sort of episode mid-trial during your cross-examination. Is that your
Yes.
testimony?
Yes.
Now, are you aware, though, in People's Exhibit 2, that criminal responsibility report that I previously placed in the record, that it was noted by the clinician that your claims of disassociating, quote, only occurred when Timothy was bad? Are you aware of that in the report?
No, I'm not, because that's not true.
Okay. And overall, the opinion of the clinician was that when you described your current state, you did not describe any substantial functional impairments within the context of your current confinement.
If I said that, that's not true.
Well, that was his opinion.
That was his opinion? Okay.
Yeah.
I didn't know he said that, but that's...
And here, let's go further. On page 10, I may approach? I'm showing the witness People's Exhibit 2, page 10. All right, Ms. Vander Ark, if you would look at that, and would you read right where that star starts? Please read that into the record.
Ms. Vander Ark was asked to recount her thoughts, feelings, and behaviors around the time of the alleged offense. However, Ms. Vander Ark claimed to have no memory of the events that led to Timothy's death, noting she frequently dissociated due to the stress of interacting with him.
And you can keep reading. Please read the whole paragraph.
Of note, this immediately appeared to be a self-protective response style as opposed to the result of a genuine memory deficit or bona fide dissociative condition. That is, her purported memory loss was noticeably selective and only involved the actions that allegedly caused the victim's passing. Thus, Ms. Vander Ark cannot be considered a credible historian. That's not true, but...
So, Ms. Vander Ark, we don't have an opinion from an expert that you were incompetent, correct?
Yes.
But we do have an opinion from an expert that you're not a credible historian, correct?
Looks like it.
And that's specifically as it relates to your credibility about these disassociations you claim to have, correct?
That I have, yes.
That you claim to have, correct? Have you been diagnosed medically in any of these reports with a dissociative condition?
Not in those reports, no.
Now, one of your claims in this post-conviction motion is that you take issue with Mr. Johnson not calling an expert, correct?
If that's what's in there, then we discussed it briefly. I didn't know what he was doing, so as far as if he was going to call him or not.
So I just want to make sure I'm clear. You weren't sure if Mr. Johnson was going to call the expert, or if we weren't going to have the expert here at this hearing?
For a while, I wasn't sure if he was going to call him at the trial.
Okay.
Sorry.
But you do recall meeting with Dr. King, correct?
Oh, yeah.
Yes. How did you feel that meeting went with Dr. King?
Long.
Was it thorough?
I would assume so, yeah. I mean, I don't remember the whole thing, but I know it was exhausting.
Mm-hmm. Now, Dr. King also has some opinions as it relates to your credibility as a historian, correct?
I don't know.
You don't know? Okay. So I'm looking here at Defendant's Exhibit B, page 10. And Ms. Vander Ark, I'm going to just start here where it says conclusion. Ms. Vander Ark overreported general psychological dysfunction and generated a larger than average number of infrequent responses. Are you aware that that was determined based on your psychological testing?
I mean, I think I've read it before.
Okay. You have no reason to dispute.
No,
what
I'm
he
not
has in this
disputing. That's what
report.
I'm not disputing.
Okay. In fact, you actually attached this report to your motion for a new trial, correct?
Yeah, my attorney did, yes.
On your behalf, though,
Yes,
correct?
yeah.
Yes. And so we have one clinician saying that you're not a credible historian and another saying that you overreport general psychological dysfunction, correct?
That's what they say.
Ms. Vander Ark, there is no medical opinion now that determined you were not competent to proceed with trial, correct?
Correct.
You have no medical evidence today that you've presented it. I'd move to strike that non-responsive answer from the record.
I will.
Thank you.
It's non-responsive.
So I'm going to shift gears here a little bit. In your direct examination, you've provided multiple other individuals that you want to place blame on for what happened in your criminal case. Is that fair to say?
I mean, I'm not going to dispute it, yes. I don't remember all that testimony.
Well, just today. Today
Okay.
you said that It was your ex-husband's fault that Timothy came into your care, correct?
Well, he asked me, yes. That's what he told me, and that's why I took him.
And it's your testimony that it's the jail's fault for your housing situation that exacerbated your mental health, correct?
I didn't have any choice in the matter, so yes.
So that's a yes or no. Are you blaming the jail for your mental health?
For making it worse, yes.
So we have, you're blaming the jail, you're blaming your ex-husband. Now, you've also blamed Timothy today, didn't you?
As far as what?
As far as his behavior is causing you to act the way you acted.
As far as causing chaos, yes. I mean, as far as causing stress, yes.
And now you blamed work as well, saying that caused stress. Your employment before your arrest.
I mean, work always causes stress.
This has been a consistent theme for you, where you want to blame others for things you've done, correct?
I've explained the situation.
Well, so what you're saying, it's your ex-husband's fault, it's the jail's fault, it's Timothy's fault, it's now your trial attorney's fault that we're here. So is it fair to say it's a theme of yours to point the finger at others for what's going on in your case?
I wouldn't say it's a theme, no. That's an opinion. You can see
All right.
the things that I had no say in that you can't blame me for.
Now let's talk about those the testimony you had about your being held in, you said it was max security during the
Yes.
pre-trial phase?
Yes.
Correct? You said you were locked in there and isolated?
In a room by myself, yes.
Okay, yes. Was Timothy also locked in a room and isolated when you locked him in the closet?
He wasn't locked in, but he was in the room, yes.
Okay. When you had alarms on his door to keep him in that closet, was he isolated?
Yes.
And he'd be locked in there for hours at a time, correct?
I would assume so, yes. I don't...
Yes or no? Was he locked in there for hours at a time?
Yes.
And you want the court to use your isolation as a basis for making a determination about your mental health, correct?
It has an effect on it, yes, it does.
What about Timothy's mental health? What impact did your locking him away, isolated, have on his mental health?
I have no idea how to answer that.
Truthfully, that's what you're here to do.
That is truthfully. I have no idea how to answer that.
Now, you talked about some of his diagnoses, correct?
Yes.
Obviously, it wouldn't be beneficial to him to be isolated like that, correct?
Yes. I mean, he isolated himself, too. He did not. I offered to... There were kids in the neighborhood, and I actually specifically asked them. He wasn't the most coordinated kid in the world, but they were playing basketball one day, and I said, hey, can he come over? They said, anytime. He never wanted to do that. When we went to little man's baseball games, he stuck to himself or with us. He didn't want to go talk to the older kids.
So it's your testimony that Timothy isolated himself?
Some of the time. Not all the time, but some of the time.
Timothy, who you went to such lengths to keep away from your in-laws that you were tracking their location so that your child G would be outside when his grandparents arrived, is the one that isolated himself.
I did not. That was not the point of finding out where Mom was. It was because the house was a mess. It wasn't. It had nothing to do with Timothy. That thought it hadn't even entered my mind until I got asked about it at trial.
You expect the judge to believe that Timothy did this to himself, correct?
Can you define this?
Well, that's what your testimony is
I'm
that
saying-
he isolated himself.
I said some of the time, and you said this. That's
Okay, I'll clarify. He isolated himself in that closet
some of the time. Some of the times downstairs,
where he had nothing but a tarp in there. He isolated himself in there. Is that your testimony?
he tore apart a mattress. But
That was not an answer.
some of the time, I said some of the time.
Did he isolate himself in those ice baths?
I wasn't there for that.
But you ordered it. correct?
I don't remember.
You had a cell phone at the time this happened, right?
Yes.
And you were messaging with your other son, Paul, correct?
Yes.
And those messages speak for themselves, right?
I'm not disputing the messages. I'm just telling you what I do and don't remember.
Now, you testified earlier today, you were, quote, barely surviving. Do you remember testifying to that?
Yes.
You were surviving just fine. It was Timothy that was barely surviving, correct?
I wasn't aware of enough of what was going on around me. I wasn't, I admit that.
Now, another claim in your post-conviction motion is how your attorney, Mr. Johnson, handled the surveillance video from that closet, correct?
The motion about it, yes. Oh, yes, I know what you're talking about, yes, from the brief.
And so you are claiming that it was ineffective or deficient of Mr. Johnson to let the police officer testify to the contents of that video, correct?
I mean, if that's what's in, I trust my attorney with that, so.
Did you observe that video?
No.
You were in that video, though, to your knowledge, correct?
As far as I know, yes.
And that video has been described by multiple individuals as extremely graphic and haunting. Are you aware of that?
I think I've heard that, yes.
And that video actually, in fact, shows your son take his final breath. Are you aware of that?
I did not know that, no.
And it shows what you were doing in the time leading up to him taking that final breath. Are you aware of that?
I would assume so.
Are you aware that it shows you being extremely cruel to him in those moments?
I don't know.
Are you also aware that after he's passed away, it depicts you dragging him out of that closet? Are you aware of that?
I remember performing CPR, so I guess was what happened before that.
Okay, one second. Thank you. Are you aware that at the end of that video, after you pull him out, there's audio about telling him to stop faking it?
I have no idea what was in it.
Are you also aware that before he passes away, you call him a dummy?
There was something said about that at trial.
So it's your testimony that that was just a stupid thing to say to your dying son?
A
To
stupid,
insult him?
it's a stupid thing to say to your child, period. Is what
Yet
I'm
you
saying.
said it, correct?
Yes, I mean, I'm not disputing it.
Do you believe that your attorney should have let the jury view that video in its entirety?
No.
Okay. So you think it's probably a good trial strategy to shield the jurors from seeing you on video insult your dying son, correct?
Yes.
It's probably a good trial strategy to not have the jurors personally witness his last breaths, correct?
Yes.
And it's probably good trial strategy to not have the jurors observe you telling him he's faking it when he's already dead, correct?
Yes.
Now, it's your testimony that during the trial there was some discussion about the manslaughter instruction, correct?
What do you mean? I'm sorry, can you rephrase that?
So you testified on direct that when Mr. Johnson came to the jail, he was discussing jury instructions.
Oh, you mean this hearing? Yes, I'm sorry.
I'm sorry,
I was
not this
confused.
hearing. I apologize. The trial. During the trial, there was a discussion that Mr. Johnson had with you about the manslaughter instruction?
Yes.
I'm going to ask a couple of questions that sort of dovetail off of the court's questions here, though. And I'm sorry to go backwards, but you said when you're having these dissociative episodes, you have involuntary movements? I'm sorry, it's being recorded. So
Yes, I'm sorry.
And let me ask you this. Was it an involuntary movement for you to grab the garbage can while you were testifying? Or was that unintentional?
I don't know what you mean. I mean, I was going to throw up.
Okay, so did you make the choice to extend your arms and grab it?
Yeah.
And did you make the choice to lean your body over?
I don't know. I don't know on that. I mean, I was about to throw up, so.
Did it happen by accident that you were positioned that way?
I mean, no.
Okay. Are you aware there was no vomit in that garbage can once you left the courtroom?
I dry heave all the time. I dry heave from motion sickness before I got the motion sickness meds I used this morning for the trip over.
Okay, let's talk about that. So didn't you claim at the last hearing that you had some motion sickness on the way into court?
Yes, I did.
And do you recall whether or not that was supported by any of your transport team?
I remember they said that they had glanced at me in the mirror. I mean, I know I was dry heaving. I didn't actually throw up anything, but that's because I didn't eat intentionally, because I knew I get motion sick.
So do you remember, I believe there was some in-court inquiry to your Department of Corrections officers. Do you remember them saying something from these seats back here at the last hearing?
I remember them talking from there, yes.
Okay, and I believe the judge, and I don't have the transcript, but I believe the court may have even sworn them in briefly for a couple
One of them, yes.
One of them, yes. And it was as to your claims of motion sickness, or how you were feeling on the transport.
How I was feeling on the transport, yes.
And there's no mention of you vomiting in that transport van, correct?
No, I dry heaved. I didn't have anything on my stomach to throw up, thankfully.
Ms. Vander Ark, you were here for that November hearing, correct?
Yes,
And you sat in the courtroom while the other witnesses testified, correct?
yes.
Is it your testimony today that they all were lying about what happened in the jail before the Friday start of the trial?
What do you mean?
Well, so let's talk about it. We had multiple individuals who testified about your desire to not come to court, correct?
I know at least one said that, and I do remember making comment, I don't want to, but most of it was I can't.
Okay, but you did say the words, I don't want to.
Yeah.
Is that a yes?
Yes,
And you ultimately memorialized that in an affidavit.
yes.
And you don't dispute that that is something you signed, correct?
No, I don't dispute it. I signed it.
Do you remember? Actually, let me strike that. Let me rephrase. Miss Kentucky testified about her observations of you
Yes,
that morning, correct?
yes, she did. Although hers were different than Fred's and mine, but some of them.
It's fair to say you have some selective memory about what you remember from that morning, correct?
It's not selective at all. I still have memory issues to this day.
So it's fair to say, though, you remember some of the things enough to
Some
say
of it.
Miss Kentucky's is different than yours.
Well, because I sat there and I was the one that wrote the affidavit. And I sat here when Mr. Johnson said that, and officer said that I was curled into a ball on the floor, and then she said I was up in a chair, that it wasn't as bad. But he described it, I mean, the most accurate total description was what he did, what he described and the officers described. Hers wasn't as accurate.
So you're saying that Mr. Johnson's description of you that morning is accurate?
From what he said, as far as curled up into a ball and not able to communicate, yes.
So I said yes or no. Mr. Johnson's testimony about that morning is accurate?
As far as I remember, I'd have to
Yes
go back.
or no?
Yes.
Okay, thank you. I have nothing further.
All right, Mr. Ambrose.
Are you saying all of Mr. Johnson's testimony was accurate?
Absolutely not.
Okay,
Not even close.
all right. You were seen by a number of professionals, correct?
Yes, sir.
One of those professionals is Dr. Colin King, is that correct?
Yes, sir.
And the prosecution mentioned that on page 10 there is a conclusion part, and you testified as to that, is that correct?
Yes, sir.
The ultimate conclusion on page 11 of Dr. Collins' report, can you read that, the highlighted portion?
Yes, sir. After reviewing the text messages with Ms. Vander Ark and the police report, Ms. Vander Ark continues to insist that she did nothing wrong and was not convinced that her actions and instructions caused the death of her son. This clinician is of the opinion that Ms. Vander Ark truly believes that her actions were appropriate and not harmful.
Okay. And this is a report that Mr. Johnson gave you?
Yes.
And you talked about this with Mr. Johnson?
I don't remember how much we talked about that.
Okay. As far as you're aware that you've always expressed your innocence to Mr. Johnson.
Absolutely.
Did you ever concede or ask him to concede to anything?
Absolutely not. I never would have.
Now, after day 3, after your testimony, were you seen by any medical personnel?
No.
On day 4, were you seen by any medical personnel?
No, sir.
I have nothing further.
No, Your Honor. Thank you.
I had some questions. Ms. Vander Ark, I think you testified at the beginning of your testimony for Mr. Ambrose, is that you said on day 1, Mr. Johnson told you that you had to testify. Is that true?
No, I said I knew I had to testify.
You knew you had to testify?
Yes, sir.
Okay. And did that conclusion come from the conversation between the two of you? Or was that something that you were already had concluded in your mind even before you talked to him?
I think it was mostly I concluded. I mean, we discussed it, but I kind of knew that from the first time.
So you knew it. So you're telling me this idea of you testifying came independently even before you had spoken to Mr. Johnson?
Yes, sir.
Okay. And then did Mr. Johnson discourage that idea? Did he encourage that idea?
He agreed with me the whole way. We talked about that multiple times and the whole process, and we always said I had to testify. There was never a question in that.
You said that Mr. Johnson, the discussions between the two of you, it's largely centered around that the prosecution had to prove intentional acts. Is that true?
For the child abuse charge, yes.
Okay.
Intentionally or knowingly?
Intentional and knowingly. Okay. And you said you two agreed that, based on what you were telling him, that intentional and knowingly had not occurred.
That's correct.
Okay. Was there ever discussion after that about, well, it's potentially, there could be a negligence argument here?
No, we never
Never talked
discussed
about
it.
that?
Never.
You had indicated that you saw Mr. Johnson, you said around 2 to 3 times during that first month after you were arrested and taken to the jail. Is that correct?
Yes, sir.
Okay. After that, you used the phrase, I saw him once in a blue moon. Can you give me an approximation how often that you believe you saw him going forward? Once a month? Twice a month?
It wasn't. I think when he testified, he said once every other month. I don't feel like it was even that often, but I don't know.
What's your independent memory of how often you came?
I would say once every few months.
Once every few months?
Yes,
Do
sir.
you mean 3 months?
At least 3, yes, sir.
So once every 3 months. Okay. All right. Did that frequency increase as the trial approached?
I don't feel like it did. I mean, there was a couple at the end that were closer together,
Okay.
but
The month before the trial, can you tell me how many times you remember him visiting you?
I'm thinking 1, 2. There was 2 actual visits, and then we came in here for 20 minutes
Okay.
to do a little bit of prep. just a few minutes.
I want to make sure, I should have prefaced what I was saying. When we talk about Mr. Johnson, I mean himself,
Yes.
not any other member of his team.
No, I mean,
Okay, so those what you were testifying to was Mr. Johnson himself? Is that
Yes.
correct? Okay. Were there any other members of his quote-unquote team that had come and talked to you outside of those times when Mr. Johnson had come individually? So separate from Mr. Johnson?
you mean just before trial, or what do you mean?
No, well, let's start. You said 2 to 3 times Mr. Johnson the first month. Was there anybody else from his quote-unquote, let me go back. What did you know of his team? What did you consider his team to be?
I knew he had some interns. He had the original social worker. I don't remember her name. I'm sorry, I'm bad with
So
names.
social worker?
She came in once a week to the jail for a while.
Okay, once a week. Okay.
And then that was it. We came in for a hearing. I think it was to something about competency, and Nick Goings was there.
Okay.
So I knew he was on the team. And then both the social worker and Fred had mentioned a research attorney.
Okay. Did you ever meet the research attorney?
No, I did not.
So you believe 2 interns, research attorney, at least one other attorney, Mr. Goings, and you believed he was an attorney, correct?
Yes. Oh, I knew he was.
And Mr. Johnson, is there any, and the social worker, was there anybody else that you knew was on this team?
Not specifically. I know he would say he had people working on it, but that's
All right. And you're saying the social worker came in every week?
for a while. Before that one left. She left the public defender's office.
Okay, do you know approximately when?
I have no idea. I'm sorry.
That's
But
okay. And then when a new one took over, did that social worker come?
I saw her twice, I think, in person
Twice.
before trial.
Okay, all right. In terms of the interns, how often did you see an intern?
They actually did not come like he had said they would.
They never came?
One came with him. It was the same one a couple of times.
Okay.
I don't know, 2 or 3 times. It was there at the end. She sat in on the trial, too.
So did an intern ever come independently of Mr. Johnson?
No.
Okay. I read your affidavit. One of the arguments advanced by your attorney and you in the affidavit was that Mr. Johnson did not argue what you felt. Well, let me ask you a question. The dehydration argument, was that to you should have been the primary argument?
I did not know about that until the medical examiner testified.
Okay.
So when I realized that, I asked him to ask about it, but I think he only asked one question, and that was it. I didn't even know about that until that day.
Okay, in your affidavit, it says, and this is one of the paragraphs, this is page 11. It says, the medical examiner stated that one of the main causes of death was dehydration. It says, I specifically asked Mr. Johnson to examine this much deeper. There was no accusation against me regarding depriving Timothy of water. This alone could have raised a reasonable doubt that Mr. Johnson never pursued this subject at all. When you make the statement, I specifically asked Mr. Johnson to examine this much deeper. Are you saying, was this before the trial, or was this after you heard the medical examiner testify?
This was after I heard the medical examiner testify.
Okay, so it's your testimony, and when you said you asked Mr. Johnson to examine this much deeper, was that during a break after the ME had testified?
No, it was in the middle of it. I wrote him a note.
Well, you wrote him a note?
Yes.
Could you recall what the note said?
I put dehydration ? And I said, please ask more about this, because
That's
he
what
had
you wrote
access to
on
water. Yes, sir.
Okay. And it's your testimony that he did not?
No.
Okay. I don't want to go too much into what could have, should have. Did Timothy have access to water?
Yes, he did.
Okay. Was he cognitively capable of getting water on his own?
Yes, he was on the spectrum, but the only symptom he really showed was awkwardness. He was grade level. He was passing all his classes. And, you know, he could communicate. He did interact with some people at Little Man's baseball games, but he just was awkward. He didn't want to hang out around other kids. And he was 15. He was, you know, you try to hug him, he's like, Mom, go away. But no, he could communicate just fine. Trust me, he could communicate just fine.
And I just want to be clear what you believe the argument that should have been made. You believe the argument that should have been advanced to the jury was that Timothy caused his own death by not drinking water.
I mean, I think that something should have come up. There was, and I just told Ms. I probably can't even.
Is that the argument? Is that the argument that you believe should have been advanced to the jury, that Timothy caused his own death because he stopped drinking water?
I think it should have been mentioned, yes. He had suicidal stuff before I got him, so he was hospitalized.
He had suicidal stuff?
Yeah, he was actually hospitalized for suicidal ideation. His stepmom told me that.
Okay. So you believe that an argument should have been made that Timothy essentially consciously caused his own death? He was suicidal. He committed suicide.
I mean, I don't know what happened, so, but it's...
I know that. I understand that. But I'm trying
I think it should have been brought up, yes.
Okay, all right. I understand. Okay. Did your concerns with Mr. Johnson's representation, did those arise prior to the trial?
I was worried about it along the way, yes.
Okay. Did you ever attempt to bring those concerns, to the court's attention?
No.
Okay.
I wasn't in good shape. Remember, the time I was isolated, I wasn't eating, I wasn't sleeping.
Okay.
I was not in good shape.
You had the ability to write letters, correct?
Yes, but I didn't have any, I mean, for the most part, first I had a little bit of money on my account, but I didn't have any
Well, you
envelopes
can
or
write
anything.
cuts, correct?
Yes, yeah.
Right. Those are free, correct?
Yeah, you can write them, they go to your attorney.
Were you aware that you could send one to the court?
No, I was not.
Now, you were in court a couple of times before trial, is that correct?
Yes.
All right. Is there a reason you did not bring that issue to the court at the time of those hearings?
I didn't want to speak out of turn. I mean, I wasn't thinking about it right then, but I just, those hearings were for certain purposes.
So you didn't feel that you could directly bring those to the court?
Yes, yes.
All right. Just below that paragraph on page 11, it says, I testified for around 5 hours on the Thursday of trial. I was supposed to finish my testimony on Friday, including some very important questions that I wanted Mr. Johnson to ask me before I finished testifying. Do you recall what those questions were?
For the most part, no. I remember one of them because I lose weight really fast. And so, I know there were some questions about Timothy's size along the way. And then we also talked, because he's 6'1" and was like 130 pounds, and I'm small. And I was going to have him ask me about how quickly I lose weight, because if I don't eat for a day, I'll lose a couple pounds that fast. So I wanted him to bring that up.
So you wanted him to ask how quickly you lose weight?
Yeah.
Okay.
Well, family genetics. I mean, my mama did the same thing.
Okay. Now, any other questions that you can recall?
Not that I remember, no.
All right.
I didn't have a pen or paper to write them down. I didn't have that available when they put me down in the holding cell. What paper I had where I was at, I didn't have access to it.
Okay. These questions that you had contemplated, those were, I'm trying to figure out when you formed those questions in your mind. Was that on Thursday or was that on Friday?
Thursday afternoon. Thursday evening.
Afternoon.
Thursday evening, yeah, after trial.
Thursday evening, okay. At the time that these questions were formed, were you suffering from a panic attack?
No, it was after that.
Okay. Friday morning, did you formulate any additional questions?
Not that I remember, no.
Okay. I want to know there's a lot in your affidavits about what was going on in the holding cell, that you curl up into a ball, you're barely able to communicate. You asked Mr. Johnson to postpone the trial, and you recall what his response was.
Yes.
I want to know, do you independently remember that, or is that your affidavit, is that based on what someone else told you happened?
No, I remember that small portion of it. I remember bits and pieces. I remember other parts of the morning as well, but that's it. No, I remember laying there. I was curled up, and because he testified that he had explained options to me, and he did not. I asked at least 2 or 3 times to adjourn because I couldn't do it, and he said that it was just going to be the same, and that they just go on without me.
Okay. So those things you can remember, but other things you don't remember. Correct?
Yes.
Okay, so during these panic attacks, it sounds like you have, if I say lucidity, you know what that means?
Yes.
Okay, so you're saying during these panic attacks, there are brief moments of lucidity during these panic attacks, where you remember them, where you can cognitively understand what people are saying.
Not usually during a panic attack. It wasn't one solid panic attack. It was multiple panic attacks that morning, but there was times where I wasn't actually in the middle of a panic attack.
So you're saying that these, what you recall independently of these communications, is when you were not suffering a panic attack.
Yes.
So the recollections that you have are from non-panic attack instances, correct?
Yes.
That's all the questions I have. Ms. Vander Ark. Any follow-up, Mr. Abrams, to those questions? Mr. Abrams?
As far as you're aware, when was the last time that either you or Paul provided food to Tim?
I want to say it was the day before he passed. I think Paul said he'd given him something.
Okay. All right, I have no further questions.
Any follow-up?
So, Ms. Vander Ark, it's your testimony that Mr. Johnson should have probed dehydration, correct?
Yes, he knew about it the whole time and never mentioned it to me.
Well, you in fact knew about it too, correct?
What do you mean?
Well, let's go back. Were you at your preliminary examination?
Yes.
You attended it?
Yes.
And do you remember the testimony of Dr. Joyce DeYoung,
At the preliminary? The medical
the
examiner?
medical examiner?
I don't remember her testifying at the
Do you have any reason to contest the certified transcript of the preliminary examination?
No.
And in fact, on page 87 of your preliminary examination, the forensic pathologist testified his cause of death was dehydration and extreme emaciation due to malnutrition and starvation. Any reason to contest that?
No. I don't even remember her testifying.
Now, there was also, I'm sorry, I cut her testimony off short though, but a significant contributing factor of exogenous hypothermia, so exposure to cold, end quote. Any reason to contest that?
No, she's the medical expert.
The reason he had hypothermia is because he was in water for hours before his death, correct?
That's not what Paul told me. Paul had run.
I didn't ask you what Paul told you.
If that's what she
The
said.
evidence showed that Timothy was in an ice bath for hours before his death, correct?
Not the whole time, because we didn't have enough ice for that.
Okay, well, let's go to this. You had an ice maker on your counter at the house, correct?
Yes.
And that ice maker was used to put ice cubes into a bath, correct?
Yes.
And you
Yes,
were
I know.
aware of that?
Yes.
And ice is technically water, correct?
Yes.
And bathtub water is water, correct?
Yes.
So yes, it's fair to say you did not restrict his access to water when you ordered ice baths, correct?
I'll go with it. That's a really weird question, but I'll go with
Well, okay. You weren't keeping him dry by ordering ice baths for him, correct?
it. That's a really weird question.
Well, ma'am, you are saying that Timothy committed suicide by not drinking water.
I didn't say that. I said it was possible, and it should have been explored because of his previous history.
Well, do you understand that if it had been explored, that there'd be further questions about the ice baths?
I don't know.
Because naturally a bath contains water, correct?
Yes.
Which was a punishment that you ordered for your son, correct?
Once or twice, yes.
also said that your attorney asked you when was the last time Timothy was provided food. Do you recall that?
Yes.
Do you recall having conversations about putting food in front of his face and pulling it away?
No, I don't.
But you have no reason to contest those
I'm
text
not
messages,
contesting.
correct? I'm sorry, let me finish my question before you answer, okay? You have no reason to contest those text messages, correct?
Correct.
And so if they say that you said to essentially tease your starving son with a pizza roll, that Paul should do it.
If that's what it said, I'm not contesting it.
You also ordered that he be provided hot sauce, correct?
Yes.
Okay. Is that the food you're talking about with your attorney, saying you provided food?
No, not as far as I know.
You also ordered that he have hot sauce placed on his genitals, correct?
It's what the text messages says.
Is that the food that you say you provided to him before his death?
No.
Now, the medical examiner didn't determine that your son died from suicide, correct?
That's correct.
But now you're here telling the court that he was suicidal.
I didn't say for sure he was. I said it never got raised.
Well, you sort of raised it in that video that you said that your attorney should have played, correct?
What do you mean I raised it in the video?
On the morning you discovered Timothy was non-responsive in that closet. Okay, you following along with me?
Yes.
So that morning, when you discover he's non-responsive in the closet, you have discussions with Paul about telling authorities that Timothy was on a hunger strike, correct?
I'm not disputing it. I don't.
Did you, in fact, tell Paul that we need to say he's on a hunger strike?
I don't remember. If that's what it was in there, then I'm not contesting it, but I don't know. I don't remember.
And now you're saying he was on a drinking strike too, correct?
I'm saying it should have been explored. There's a big difference.
This is just another scheme of yours to try to blame Timothy for his own death, isn't it?
Not at all. There is no scheme.
Okay, maybe not the right word. Your testimony is blaming Timothy for his own death.
I'm not blaming anybody. I'm saying there's possibilities that should have been raised.
Well,
He
you're
had a
saying he was-
history of suicidal.
So you're saying he was suicidal?
I don't know. I never even thought about the possibility until that morning in court, because I honestly do not remember the medical examiner testifying at prelim. I don't.
You didn't think about the possibility until you were trying to find out a way to blame Mr. Johnson to get a new trial. Is that correct?
No, that's not true.
I have nothing further.
All right, Mr. Ambrose.
Have you seen the death certificate?
Yes. I didn't see it till that morning of trial, but
Until when?
until the morning I testified.
Okay. Do you recall what the first thing that is listed on this death certificate is?
It's dehydration.
All right. And that's kind of strange, right?
It's really odd.
Because he's in an ice bath, right? Mm-hmm. And he has access to water, right?
Yes.
And so
He didn't.
he didn't drink.
No.
You never prevented him from drinking.
No.
All right. No further questions.
Any thoughts? All right, stand up. Can you stand down? All right, Mr. Ambrose, any additional witnesses?
I do not.
Any witnesses?
No, Your Honor, just if the court would recall, we took my witnesses out of order last hearing. I have no further witnesses.
Okay. All set, Mr. Ambrose? Anything else, Mr. Ambrose?
No.
All right, I think it's important for the court, based on the testimony of Ms. Vander Ark regarding failure to raise concerns to the court. Ms. Vander Ark, I want to make sure we address you directly at this point, so you are free to talk to the court. Okay. I need to know if you believe that your attorney, Mr. Ambrose, is a little awkward, but is there anything that you believe he should do going forward at this point in time in regarding to your motion for a new trial?
No,
Are you satisfied with his representation?
very much so, yes.
Any other witnesses you want him to call?
No.
Is there anything else you want him to do?
No.
Okay, all right, good enough. All right, I think that's the evidence is concluded. The court is going to take the matter under advisement. The court will issue a written opinion, and then we'll go from there. All right.
I'm assuming that Mr. Roberts is not testifying?
No, he's not.
Okay. That was mentioned at the last hearing that he may be testifying, and I was kind of prepping for that.
Do you want to call him as a witness?
No, that's all right.
Okay, you sure?
Yeah.
Ms. Vander Ark, do you want him to testify? Mr. Roberts? All right, good enough. We're in recess. Good day. Have a good weekend.
All right, that seems to be it. Put myself over here. Oh boy. All right, hold on a sec. All right, let's go through. Let's go through what we move this over a little bit. All right, let's go through what we heard. Now, before we do, we have a poll going. Do you think Mr. Johnson represented Shanda properly? 96% of you out of 362 votes. 96% of you are saying yes, she is still guilty. And 4% of you are saying no, she should get a new trial. So let's review what we heard today. So she met with Fred Johnson. This was under direct. She met with Fred Johnson 2 days after she was arrested. On day one, they talked about general things and that she would testify. So she knew straight away that she was going to testify. She said she never admitted she was guilty. She relayed her innocence to Mr. Johnson. She said she is used to testifying. She testified between the years of 8 to 16 years old. She said her mental health was horrible. She didn't eat for 18 days. She couldn't sleep. She didn't know which way was up. Then they jumped to, when did she move to Michigan? She thinks it was in 2015. She says, a little guy. She refers to her youngest child as a little guy. So the little man. So she moved with her little guy who was 6 months old, and her late husband. Now, Paul turned 18 and right as COVID was happening, so that was 2020. He moved in May, and then Timothy moved in a year later. Actually, Paul had graduated, so he moved in after he graduated, so maybe that was June of 2020. And then Timothy moved in a year later after he finished school, so that would have been May of 2021. She talks about Timothy he had a lot of medications, a lot of prescriptions. He had ADHD, he was bipolar, high-functioning autism. She said he had 8 to 9 meds per day. She says that that Timothy's father, her ex-husband, who I think his name was, what was his name? I posted that. Eric. So her husband's name was Eric. So they had Timothy, Paul, Nolan, and Millie. Okay, after I go through this, I want to play Millie's, at her sentencing. I want to play Millie's victim impact statement. I want to play that for you guys. And then we'll play her sentencing next. All right, so Dad said, meaning her husband, her ex-husband, Timothy's dad said he could no longer with Timothy, because he was pushing his buttons. He was and he was going to lay hands on Timothy soon. Tim was about to turn 15, but nothing was outlandish, other than he wouldn't tell the truth, right? So she's saying, oh, it's just typical 15-year-old stuff. She said he would take and break toys of, I think Gabriel was a little man. He would take stuff from Paul, but it was nothing that we couldn't handle. Then everything changed. This is where she says everything changed. Everything changed after her late husband had a stroke. He had a massive stroke, January of 2022. She said she was the primary breadwinner, but now she became the sole breadwinner, so they lost income. She didn't leave Timothy alone with the little one. She said she was gone from the house 12-hour days with her commuting and her work 5 days a week. She said everything fell apart. She said she was barely surviving. She said her late husband was watching Timothy and the little guy, and Paul was watching as well. So Mother's Day of 2022, Timothy was about 100 pounds. Then May to July, which is when Timothy passed away, she says, Tim says, I'm going to keep doing stuff until you do what I want. So, okay, she doesn't remember a peaceful moment, and Timothy created a lot of it. So here she is blaming Timothy. So a month before Timothy passes away, he was going to turn 16, so that would have been, I guess, in August. Then she goes into, she was arrested July 7th. She talks about the conditions at the jail were awful. She was in maximum security, so she was isolated. She got let out 1 hour a day from the pod. She said she couldn't eat, she could barely sleep. She said she only slept 1 hour a night, maybe. She kept asking to speak to a doctor, but was always said, always was said, oh, we'll put you on the waiting list, put you on the waiting list. Let's see. All right, let's go. Audio's still fine here. Audio's still fine. If you guys lose audio, YouTube's acting up. Just refresh. Just refresh if the audio goes out. Just refresh. Seems like that's kind of happening today with YouTube. So just hit refresh. You should be okay. All right, let's see here. She says she was there for about 17 and a half months. And she has sensory processing disorder, bipolar, and ADHD. She said they talked a little bit about trial strategy. The child neglect was intentional. So she thought that they were going to go with intentional and knowingly. No. Did she intentionally and knowingly know? That's about what she did to Timothy. So the manslaughter and the first degree felony wasn't even on the table until she had no clue, until it was either jury selection or jury verdict or jury instructions. I missed that. I missed my closed captioning. I think she said jury selection. Jury selection. She may have said jury instructions in the verdict form. So I may get that. I may be off on that. But anyway, she said she had no clue until like right at the end, I guess. How are you feeling during your testimony? She says stressed, panicked, and terrified. She says during the jury question, she had a really bad panic attack. She says the noise level in the pod was horrible. She said maybe she slept for an hour that night. And here's where she says she was curled up in a ball when they came to get her. She apparently made a comment about deleting herself. She doesn't remember that though. She was in sheer panic and she was frozen. She never conceived that she was guilty. Mr. Johnson stated they didn't have intentional and knowingly, and she was not guilty, so she clung to that. So then under cross, we go into her past. So she was a law clerk, she was an intern, she did legal research and score sentencing. She would score sentencing, to make sure it was accurate. She would draft opinions and the judge would sign off on them because she got them correct. She was familiar with post-conviction motions, but she says most of them were civil. Most of those things that she wrote were civil, some were criminal. She met with 6 people on Fred's team. It wasn't just her and Fred working the case. It was a social worker, there were 2 interns, and she met with another attorney. So now she's saying 2 days after the arrest, she met with Fred. I thought she said it was one day after, but anyway. She had a medical episode during mid-trial. That was not her first episode. She had one during the preliminary examination just before Paul was going to testify. She had an episode when law enforcement was testifying, right? So it didn't happen on direct, didn't happen during openings, didn't happen during jury selection. It happens when you're confronted with evidence you don't want to see. She's like, no, when confronted with traumatic things. I don't know, seeing your son waste away? That's not traumatic? Having your son have self-deletion thoughts? That's not traumatic? I mean, she contradicts herself like left and right. Let's see what else. Yeah, okay, yeah. What about when you saw Tim every day? Was that not traumatic? I forget what she said. She doesn't have medical documentation of a panic attack that day. She met with a couple medical providers. There were 4 reports on her medical competency. So she says she understands the process. Both sides can get the report. It's never been shown that for her to be not competent. I should say not competent. Never had a legal determination of her being competent. So she disassociated when Tim was in her care, and even when he wasn't. She says it still happens. Judge asks, and then Judge steps in. He asks her to describe this panic attack. So she describes it as hyperventilating or an elephant sitting on her chest, so, difficulty breathing. So she's either hyperventilating or she has difficulty breathing. She's shaking, she's dizzy, she has no clue what's going on. People touching her makes it worse. So he asks, so are you aware of someone, touching her? She's like, yeah, but I come in and out. She says she doesn't remember hearing anything. She goes into this dark hole. She can't move her extremities. She curls up into a ball involuntarily. She doesn't know how much time passes. So that's interesting because then when she's asked about when she got sick on the stand, that was all voluntary. She reached for the bucket, she reached for the can. That was all voluntary. That wasn't involuntary. She doesn't know how much time passes. It happens in her room or in restrooms or the common area. Now this got really interesting. I can't wait for this. So she knows the common areas are filmed. So she says someone came up behind her and scared her, and she went into this panic attack. So the judge is like, you do realize that, or I forget if it was judge or prosecution asking, you do realize that there's cameras there. So you're saying you had a panic attack between August 2024 and January 2025. So let's go and let's see if we can find that. We won't be able to, but I'm sure the state will be able to find that. So let's see what her panic attack, let's see what panic attack actually occurred. So it only occurred when Tim was bad. She says that's not true. She says, so she reads this opinion by one of the doctors, and it says she can't be considered a credible historian. She's like, that's not true. She mutters under her breath a lot, that's not true. Or whatever, that's not what happened. That's not true. Yeah, that's not true. Everybody's wrong. Shanda's right. She wasn't sure if Fred was going to call an expert. So then Dr. King, Dr. King was one of the psychiatrists, I think. I'm guessing, anyway, therapist or whatever. So Dr. King's meeting was long. Doesn't remember the whole thing. She said it was exhausting. Dr. King has opinions about her credibility as a historian. She generated a larger and unusual amount of infrequent responses. So no medical opinion saying she wasn't competent to stand trial. No one bothered to get one. That was struck from the record. She's like, yeah, no one bothered to get one. Again, she's like throwing in all these side snide comments. She wants to place blame on another of people. So she places blame on her ex-husband for sending Timothy to her. She places blame on the jail for the housing. She places blame on Timothy's behavior because it caused chaos and stress. She says, and what about work? She's like, well, work always causes stress. I don't know about you guys, but I don't know. Work doesn't always cause stress. Sometimes work is pretty fun. Else, go find another job. If work is causing you stress, go find another job. Simple as that. You spend 8 hours, 9 hours, 10 hours a day times 5, 40 hours a week, and you're stressed out, go find another job that doesn't stress you out. Simple as that. I have no empathy for that. This has been a consistent theme for you. And then she says, now it's your trial attorney's fault. So Shanda's, of course, shaking her head. It's not a theme. That's my opinion. Things I had no control over, I can't be blamed for. You had control over your son. You are your son's parent. You are the parent. You have custody. Even though she says she didn't have legal custody, you are in control over your son. So you did have control, Shanda. Tim would be locked in a closet for hours at a time. She wants the court to use her isolation. She's like, what about Tim's mental health when he was locked away? She's like, I have no idea how to answer that. Now she's saying Tim isolated himself too. He never wanted to play basketball. He isolated himself some of the time, not all of the time. And oh yeah, when the in-laws came over, she would keep him outside the house because the house was a mess. It had nothing to do with Tim. Yeah, well, that's a side product. That's a side byproduct. If the in-laws had come in and they had seen the mess, they would have been like, whoa, what's going on? What's Timothy up to? Whoa, Timothy's 100 pounds. We need to he's coming with us. So your house being a mess, sure, but they would have seen Timothy in his state. Do you want the judge to believe Timothy isolated himself? She's like, Timothy tore apart a mattress. Then we get into these ice baths. She says, I wasn't there. I don't remember if I ordered it. So she's conveniently, I don't remember this. I don't remember that. So, yeah. She was barely surviving. State asks, well, what about Tim? She's like, I wasn't aware of that. How can you not be aware? How can you not be aware that your son is wasting away? By your hand or by Paul's hand. Somebody's causing that. Oh, what about if Timothy? Okay, so let's go down that path. She's saying it was Timothy. Timothy had self-deleting ideation. Okay, did you get him any help? Oh no, she said, I didn't have legal custody, so I couldn't get him to a doctor. Sorry, that don't fly. Take him to an emergency room. I don't have to. If I see somebody laying on the side of the road and they're injured, I have full right to take them to the emergency room. I don't have to have custody over them to take them to the emergency room. So, sorry, Shanda. I'm calling you BS there. Anyway. So she's not disputing the text between her and Paul. She said she was barely surviving. State asked, well, how about Tim? She's like, I wasn't aware of that. So again, her recollection is if it goes against her, she's like, I wasn't aware of that. If it's in her favor, she's like, well, whatever she does, I don't care. Then there's the surveillance from the closet. She was claiming ineffective. It was ineffective for law enforcement to testify about that. Notice she didn't observe that video. And remember, Mr. Johnson called that one of the most disturbing, haunting, horrific things he's ever seen, right? It's been described as extremely graphic and haunting. It shows Timothy taking his last breath. She doesn't know that. Why didn't you watch it? Why didn't you watch that video? Why didn't you watch that video, Shanda? Why didn't you watch that video of your son taking his last breath? It shows her being extremely cruel. She didn't know that. Why didn't you watch that, Shanda? Why didn't you look at that? She only remembers performing CPR, and she guesses that, because apparently she pulls him out roughly. So she says, well, I guess that's what happened because I was pulling Tim out of the closet. And then after she pulls him out, she says, stop faking it. She's like, I have no idea. I have no idea what's in that. She says to Tim, you're a dummy. She says, we all say stupid things. She said to Timothy as he's laying there passing away, she says, you're a dummy. And she says, we all say stupid things. Then she says she's not disputing that. So she admits to calling Timothy a dummy as he's taking his last breaths. And she says we all say stupid things. All right. She thought it was a good strategy to not show the jury the video. The intentional, okay. Oh, then we get into when she threw up. So were those intentional movements when you grabbed the garbage can? Remember, because she's saying when she has a panic attack, she's like, I can't move, I can't move. Well, she intentionally went to grab the garbage can. Those were intentional movements. And then it's like, did you know that there was no vomit in there? She's like, well, I dry heave all the time. She had motion sickness the last time, but that wasn't supported by law enforcement, and we heard that yesterday when we showed that from November. She dry heaved. Not drive. She dry heaved because nothing was in her stomach. Oh, and then Miss Kentucky. So that was Kentucky was her name. That was I think that was a social worker. So the social worker said that she was sitting in the chair, and the law enforcement said, or she said that she was on the ground. So the most accurate was law enforcement. I guess they were saying that she was on the ground and Fred, not Miss Kentucky. That was last November. Then we get to redirect. So all of Mr. Johnson's testimony wasn't even close to being accurate. So she says all of his testimony last November wasn't even close to being accurate. Yeah, Timothy was 69 pounds when he passed away, you guys. I see you looking up. He was 69 pounds. He was 68 inches tall, and he was 69 pounds. That's from Dr. Joyce DeJong. No body fat, cheeks were narrow, could count all of his ribs. Cause of passing was dehydration and extreme emaciation due to malnutrition and starvation. So his last medical record from Oklahoma was April 6th of 2019. He weighed 95 pounds when he was 12 years old. So here he is 15, and he's weighing 69 pounds. So all right, let's see what else. So we're going through redirect. So she talked about testifying with Fred the whole time. We knew that. Okay, conversation of the charge of intentionally and knowingly had not occurred. So she didn't know about dehydration until the medical examiner testified. Shouldn't that be in discovery? Shouldn't that be in discovery? Shouldn't she know that? Shouldn't she know what each? Well, Mr. Johnson should know, right? That's all in discovery, because you have to know what they're going to testify to so you can cross-examine them. So she said in the middle of testimony, she wrote him a note about dehydration, question mark, exclamation point. Please ask more about this. Fred did not pursue that line of questioning. So that's why she's saying, I got ineffective counsel because he didn't question about the dehydration. Did Tim have access to water? She says, yes, he was on the spectrum. He only showed awkwardness, meaning he didn't want to interact with other people or he didn't want to be hugged. So is this the argument? Tim caused his own passing by not drinking water. She says, yes, Tim was and here's where she brings in, Tim was hospitalized for self-deletion ideation. So her stepmom told her that. So she heard that from Tim's stepmom. She thinks that should have been brought up. She thinks that should have been brought up. She didn't want to speak out of turn. That's why she didn't bring it up, even though has no problem writing notes after notes after notes. She asked Fred to postpone the trial. That's when she was curled up and having a panic attack. She said, he explained the options to me. Oh, he said he explained the options to me, and he did not. So in his testimony last November, she says, Fred, under testimony, said he explained these options, and she's saying, no, he did not. He did not explain those to me. During a panic attack, she says she can remember some moments. She's had multiple ones that morning and remembers, in between moments. And this was all judge asking all these questions. And then the lawyer comes back in. Last time provided Tim was the day before. She says, I think Paul said he had given him some food. So she's relying on her 20-year-old son, 20, right? He was 21 years old, to say, yeah, I gave him some food, instead of actually checking in on her son to say, hey, son, did you have dinner? Hey, son, did you have breakfast? Hey, son, let's have dinner. Hey, son. So, sorry, Shanda, not flying with me. All right. Then we get to recross, I'm sorry. So Fred, she says Fred should have asked about that dehydration. But then there was a preliminary examination. The pathologist said death by dehydration. She doesn't remember that testimony. So in other words, the trial was not the first time she heard that Timothy passed away from dehydration. And the cause of Timothy's passing was dehydration and extreme emaciation due to malnutrition and starvation. Evidence shows that Tim was in an ice bath. She's like, well, we didn't have enough ice for it to be for hours. And she was asked, you didn't restrict water when giving ice baths. She's like, that's a really weird question, but I'll go with it. She admits ordering the ice baths once or twice as punishment, so she admits that. She doesn't recall having food put in front of Tim and then pulling it away. She won't contest that she teased Tim with that pizza roll. Remember, there was those texts between Paul and her about, put a pizza roll in front of his nose or his mouth, and if he goes to bite it, then pull it away. Let's see. The whole thing about Timothy self-deleting, that was never raised in court. The video of Tim's passing, it shows her and Paul talking about make sure you tell law enforcement that Tim was on a hunger strike. She doesn't remember that. She says she won't contest that. She says, though, it should have been explored. And then she's not blaming anyone, but there's a possibility that should have been raised. Then on redirect, she has seen the death certificate. She saw it the morning she testified. Dehydration being listed, she says, is really strange. Of course, he had access to water because he was in an ice bath. She did not prevent him from drinking said water in said ice bath. And then the judge finally says he asks her directly, he wants to know, did Mr. Ambrose do everything for you? Should he do anything else moving for a new trial? And she's like, nope, he's done everything. Are you satisfied with him? Yep. So he made sure, are you okay with this counsel? The court will offer a written opinion, and then that's it. That's it for that. So I want to show her daughter's sentencing. Let's go back to her sentencing. Let me see here. All right, here's her sentencing. Actually, you know what? I want victim impact statements. I want you to see her daughter's victim impact statement, because I want to see that again too. Do you guys remember victim impact statements? Okay, yeah. All right, here's her daughter. There's a couple of victim impact statements. I want you guys to watch this. I want to revisit this as well.
Okay. Nothing to say. We are on the record in file 23110 FC. It's people of the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark?
Yes, sir.
All right, Ms. Vander Ark appears before the court with her attorney, Mr. Fred Johnson. The people are represented by Matt Roberts. The date and time scheduled for a sentencing in this case. Have the people had a chance to read the pre-sentence report and the attached guidelines?
We have, Your Honor, we have no additions or corrections, although I have been advised by Mr. Johnson that he does have a number of corrections. We've discussed those over email. But for his objection to the restitution award, we have no objection to the corrections that he is seeking.
Okay, I did get an email from Mr. Johnson. I appreciate that. Why don't we just go through each objection just to make sure we have them all on the record, and then I'll inquire to Mr. Roberts whether or not he objects to that. So you may proceed.
May we start with the very first page one, the first page one?
Okay.
As I noted. Under the personal history information, it notes that my client's educational attainment has been a bachelor's degree. We're asking the court strike that and insert the words Juris Doctorate.
Any objection, Mr. Roberts?
No objection, Judge.
Okay. And then just for probation notes, I'll, Ms. Anderson, I will send you, did you get a copy of the email?
I did not, Your Honor.
All right, I'll forward that to you just so you'll have it in writing exactly what all the corrections are. So, all right, go ahead, Mr. Johnson.
On page 2, the very next page, at the under the rubric jail credit, it indicates that the dates that we're in question here are in July 7th, 2022 to January 19th, 2024, and we're asking the court to amend that to today's date, the second date, January 23rd, 2024.
Any objection, Mr. Roberts?
That checks out, Judge. That'd be 4 additional days, so 575 days of credit.
Okay.
That is our position. Wow. Thank you. Let's see here. Make sure I don't miss anything. Judge, on page 2 of the interior of the document, the second page 2, on the let's see, 1, 2, third paragraph down, there's a request for restitution for $5,000 to the Michigan Department of Health and Human Services. We object to that request. We ask that the court disallow that request at this juncture. We haven't received any information to justify it, and we'd ask for a hearing if the court plans to proceed on that.
Mr. Roberts?
Your Honor, that request is made by the Department of Health and Human Services as compensation back to the Crime Victims' Rights Compensation Act. That fund did pay out some funeral expenses as a result of this, and the fund is entitled to seek compensation from the defendant in those cases. I think it would end up being joint and severally liable with Paul Ferguson as well if we get to that juncture with Paul Ferguson. But we do believe it is an appropriate award, and there is documentation from the state to indicate that that award was paid out. So we would request that $5,000 be ordered.
Has Mr. Johnson been provided that documentation?
He may not have. I can forward those to him. So.
Mr. Johnson, would you prefer to just have the restitution portion reserved until you can receive the documentation? Then if you so choose, you can ask for a restitution hearing. I guess what would your preference be, or Mr. Roberts, what your preference would be? I mean, I can order it with the ability for Mr. Johnson to come in and ask for a hearing, but I guess it depends on what either one of you would like to do.
If I could just make a suggestion, I would prefer that. In lieu of that, the only other thing I would ask that is if I can get the information to Mr. Johnson. My understanding is Ms. Vander Ark has another matter which is being handled in front of a different judge at this time. That case is not going to finish today, and she will be here at least until tomorrow. But perhaps by then we can work out this restitution issue and just move forward that way with the court ordering it. And then if Mr. Johnson chose at a later time to challenge it, certainly he would have the right to do that through a motion.
Okay, yeah, what I'll do is, I mean, I think the paragraph in there saying that they're requesting restitution, I don't think there's any need to strike that in terms of ordering it. What I'll do is I'm going to order it with your opportunity, Mr. Johnson, to request a hearing. And obviously, if you want a hearing, we'll have a hearing on it. And if you don't, then it'll stand as ordered.
Thank you, Your Honor.
I'll provide Mr. Johnson the documentation we have as well, so
I know.
he can review that, Judge.
I know.
Okay. You can continue, Mr. Johnson.
Page 3, Judge, and this first one was not in the email that I sent to the court. This is one I was able to identify later on, and it's in the very first sentence. The first sentence reads, "It is therefore recommended." I think there was intention that the words "there" and "for" be combined into "therefore."
Okay.
To make that correction.
I would agree.
Objection? Mr. Roberts?
No objection.
All right.
On the third paragraph, under description of offense narrative, in the last line of the third paragraph, there were visible bruised on his chest. I believe it ought to have been bruises on his chest, and we'd ask to make that correction.
Okay.
No objection.
On page, if the court will go forward to page 5.
All right.
Let's see, 1, 2, 3, 4, 5. Paragraph 6. There's a description of the plea negotiation for Paul Ferguson there, and while we don't object to what's stated, we would like to add language that, in addition to what's stated, that the people have agreed to fairly and fully inform the court. And I think that was testified to as part of the agreement.
That is accurate, Judge, so no objection to that.
Okay. All right.
Okay. On page 7, under the heading of employment, under unemployed, then it says 17th Circuit Court. I believe the intention was to say 27th Circuit Court, Your Honor. That's where the employment was, in fact.
Yeah, I did see that. I think the 17th is actually Kent County, I believe, so it's the 27th Circuit Court. Any objection, Mr. Roberts?
No objection.
All right.
And, Your Honor, we're asking the court to add to the employment that my client was also employed with the 14th Circuit Court as a law clerk as well. When were you?
January 2021 to August 2021.
January 2021 to August
2021.
2021, Your Honor.
Okay. Any objection, Mr. Roberts?
It's a fairly minor point, but I think technically that was an internship. I don't know if that qualifies as employment, but I'm not. If the court wants to put that in there, that's fine.
Yeah, I thought the same thing. I mean, we don't differentiate between, I guess we can say rate of pay as an internship. I think that kind of will make sense to me. Any objection to that, Mr.?
That's appropriate, Your Honor. We would support that.
Okay. All right.
And on that same page, Judge, under colleges, advanced degrees, the second one down, West Michigan University, Cooley Law School, under level completed, it says 4 years college, and it should be 3 years. And the area of study should be law, not legal assistant.
Okay. Any objection, Mr.
No
Roberts?
objection, Judge.
All right.
And certificate, I'm sorry, you're correct. Certificate should be Juris Doctorate.
All right.
Correct.
Okay.
Okay. On the next page, page 8. And this also was not included in my original email, Judge, under mental health, where it says bipolar disorder.
Okay.
We now have the medications that's been prescribed, and I'm going to spell them for the record. The first one is Lamictal. Lamistal?
It's Lamictal, C, not S.
Okay. Lamictal.
TIL.
TIL. Okay. Lamictal. And it's spelled VISTARI.
L.
TIL.
L at the end.
Okay. VISTARIL. Visceral. And the treatment commenced in 2024.
Okay.
The third page one, the following page, under basic information, highest grade completed. It says bachelor's degree. That should be Juris Doctorate, Your Honor.
Okay. Any objection, Mr. Roberts?
No objection.
And thank you, and I have no additional corrections to make to the PSI.
All right. Any additions or corrections to the guidelines at all, Mr. Roberts?
No.
And Mr. Johnson? Any corrections or additions, any corrections of the guidelines?
No, sir.
Okay. Any challenges of the guidelines, Mr. Roberts?
No, Judge.
And Mr. Johnson?
No, sir.
All right, Ms. Vander Ark, have you had an opportunity to review the pre-sentence report and the attached guidelines?
Yes, sir.
Any additions or corrections that you have?
No, sir. I got all of them.
Okay, Mr. Roberts, I believe we have some individuals here who wish to make victim impact statements. Is that correct?
That's correct, Your Honor. The two older siblings of Timothy Ferguson, with the exclusion of Paul, would like to make a statement.
Okay, they may come forward, and whoever wishes to speak first may go ahead and, they can stay there, they can come to the podium, it's completely up to them, so.
It's Millie Ferguson who's going to be first.
Okay. And just for the record, I think Ms. Ferguson actually wrote a letter as well, I believe, and
I believe it's included, yes.
yeah, I have read that's attached to the PSI, but she's certainly welcome to make a statement. So. Good afternoon, ma'am. How are you?
I'm good. How are you?
Can you please state your name for the record?
Millie Joan Ferguson.
Go ahead, Ms. Ferguson.
Thank you. I'm Millie. I'm Timothy's youngest older sister. I'm 2 years older than him. One of my earliest memories I have was being taken away from my parents by CPS. My two older brothers rode in a car ahead of us, and me and Timothy rode together in the second car. And in every picture we have as a family, Timothy was always right by my side. We were the two youngest, the two smallest. We were the two that sat in the middle in the backseat car rides with the too small car. The last two to get hand-me-downs, the two that never had to worry about not getting homework help from an older sibling. He was always 2 years behind me, so every time I got to the next level in school, that's how many years I had to wait for him to follow along. When I was in 8th grade, he was in 6th, and there was a student in my science class that started talking about him, trying to start rumors. I stood up right as class was starting, as people were quieting down, and I shouted at him to never talk about my little brother. People could say whatever they wanted about me, I didn't care, but not about him, and never about him, because I was his big sister. It was my job to protect him. I like to say I don't regret things in my life, that every mistake I've made has made me who I am today, but when Timothy died, I couldn't stop regretting. I regret not hugging him more and teasing him so much instead of telling him that I loved him every once in a while. I regret not putting aside my differences with Shanda and Paul just to check in on him. I regret not dancing with him the last time I saw him at our brother's wedding. These are the things that I can't remedy now. There's no fixing what's been done. No way to redo it all over again, and that's my regret. That I couldn't protect him when he needed me most. Timothy was so smart. He could take anything apart with any tools, or none at all. He had trouble focusing, but when he did, he was just as smart as the rest of his class. He made people angry, yes, but then he would look at you with those big baby blue eyes, and you could never stay mad at him. It took me 6 months of therapy after he died to even properly feel the emotions of his death, and I'm still in therapy today. I've been trying so hard since he passed away just to try to let people know of him, let people know that he was loved, that there are people out there grieving for him. I'm here today for him because I was asked to speak for him, because I was given a victim impact statement for him instead of a witness one, because the victim of this crime can't speak for himself. I knew him his whole life. I held him the day he was born, and I continued to try to hold his hand as long as he was by my side, until he wasn't. I want the woman who killed my little brother to face the highest punishment possible. I want her detained for the rest of her life so she can't hurt anyone else. And I want the world to know that Timothy was wanted, if not by her, then by me. He was loved by me. Thank you.
Nolan Ferguson will be next, Judge.
Okay. Please state your name for the record.
I go by Nolan. My full name is Eric Nolan Ferguson, Jr.
Go ahead, Mr. Ferguson.
I am Timothy's oldest brother, and unfortunately the oldest child of Shanda Vander Ark. I live with my wife 900 miles from here, and in July of 2022, I was working 60-hour work weeks, trying to build a career when I received a phone call that I never thought I would get. My baby brother Timothy was gone. For 2 days, I reeled with no explanation until I was informed that our own mother was in jail for his murder. Somehow, making an entirely unexpected and deeply awful situation worse. I thought that things were different than when I was younger. I thought my mother had changed for the better. Not one day has been easier since then. I've had to leave my career behind. My wife has to watch helplessly as I struggle, day in and day out, wondering how none of us knew what was going on, wondering if I told Tim I loved him enough times for him to remember up until the very end. I have to wake up every day and pretend that I am who I was before Timothy died. I have to pretend to be Nolan so that my friends and coworkers and family won't worry about me more than they already do. I'm surrounded by people who love me and care about me, but not a single person besides my sisters who understand how hard it is. Timothy wasn't surrounded by people who loved him when he died, and if I had known that, nothing could have stopped me from rescuing him and holding him in my arms and telling him I love him, that his big brothers got him, just like I did the day he was born. But because of Shanda Vander Ark's actions, I instead got to cradle the bag of his ashes in my arms, just like I did the day he was born. In all my life, I only knew one thing that my little brother didn't like. He hated goodbyes. If he had to say goodbye to anyone, he would cry, and he would hold you, and he would say, "Don't go." But now I'm the one crying, but I never got to say goodbye. I will always love Timothy like I always have, and it kills me to think about, but I know he loved even his abuser and killer up until the very end, because unlike me, that's all he was capable of, love. I, on the contrary, want to stand here and express the anger and hatred that I feel, but if I'm honest, all that's just a mask, a bandage I try to put over the hole in my heart that was reserved for Timothy, but is now just filled with pain and remorse for every hug, high five, and I loved you that I might have missed in the time that I had with my sweet baby brother. So now I turn to the justice system in hopes that in addition to serving the maximum penalty, that there will be no appeals or second chances. If I can't have my brother back, she shouldn't have her freedom back. And lastly, I want everyone to know that to those who knew him, even that wouldn't feel like justice. Because the life of one sweet little blue-eyed boy is not equivalent to that of a murderer.
Thank you, Mr. Ferguson.
That's right.
Thank you, Judge. I want to preface this by saying that those of us involved in the justice system, including the defendant, know what sentence the court is going to impose here, at least for that first-degree murder charge. And it is a sentence which is as warranted in this case as ever there was a case. That life without parole is the only sentence that Ms. Vander Ark should receive. I wanted to stand here for two reasons. I wanted to stand here, up here at this podium, next to Millie and next to Nolan as they gave their statements for two reasons. One, to show that we support them, that we support whatever statement they wanted to make here today. But I also wanted to see Ms. Vander Ark. She didn't look over at her kids once. Not once during this entire process did she look over at her children. And that speaks volumes, because this case has always struck me that it's impossible as a parent, let alone as a human being, to understand the depths of the depravity that it took for us to come here today. All of the things that she did, or all of the things that she withheld, or all of the things that she directed her other son to do are so callous and so cold that they just defy explanation. And I convinced myself that the only thing that could make any sense is that on some level, she had stopped thinking of her children as human beings. And frankly, her not looking over and not even wanted to express some type of emotion or some type of remorse or some type of recognition of those two older children that she had a hand in raising and who spoke so eloquently and so beautifully and so passionately here today, just reflects what I guess we already feared and already knew about Ms. Vander Ark. By a long margin, this case has been the most difficult case that I've ever worked on as a prosecutor. There are few people that have had any contact with this that wouldn't say the same thing. Whether it's police officers, whether it's the first responders, whether it's the paramedics or the firefighters who were on the scene, who all needed counseling to get through it. To the prosecutors that have looked at this, to the other attorneys that have looked at this, to anyone you talk to, nobody can look at this and understand any of this. And certainly nothing in Ms. Vander Ark's testimony, we know it wasn't persuasive for the jury, and nothing in her testimony can provide any real insight into what was going on here. Again, other than what I feel is the conclusion here is that her children were just not people to her, that she just stopped thinking of them as that. They were, certainly Timothy was just an obstacle to her. He was a challenge that she was going to win. She was not going to let Timothy win. And she said it over and over again in the text messages. And it's just unfathomable. Again, I know the court has no discretion to impose, and we certainly welcome and stand wholeheartedly behind the court here having to impose the life without parole sentence. But I would say this, the court does still have some work to do because it does have to impose a sentence for that first-degree child abuse case. And as the court is aware, and we have not contested the guidelines in this case, they call for a minimum sentence of between 135 and 225 months. But I submit to the court, if ever there was a case where the guidelines don't even come close to reflecting the charge, it's this case. If not this case, then I can't even fathom what case it would be. Even with the offense variable scored at nearly double what would be necessary to maximize that score, that still doesn't even scratch the surface of what this woman did. I don't know, frankly, what number to suggest to the court. For years, I practiced in front of Judge Hicks. I know that Your Honor did as well. And Judge Hicks would frequently throw out numbers when he was discussing the discretion that the court has for life offenses, to throw out just numbers that just seem ridiculous. They don't seem ridiculous in a case like this. They just don't. Because nothing, again, can touch what this case was. Nothing will bring Timothy back. We all know that. We can't escape that tragedy. That the time for that has passed. But I would ask the court to send a message here that reflects how heinous, how callous, how cold, use whatever adjective you want to describe these actions, that even for that first-degree child abuse case, that's what this sentence should reflect. And those guidelines just don't even come close. So I leave it in the court's discretion here, and again, knowing that despite what decision it makes on that charge, it has no discretion with the life without parole sentence. And the only solace I take away from this, and I hope all the relatives and all the loved ones and all the people that cared about Timothy know that the only thing we can do at this point, and the only thing this court should do at this point, is to make sure that Ms. Vander Ark never sees a day of freedom again. Thank you.
Thank you, Mr. Roberts. Mr. Johnson, any allocution on behalf of your client prior to sentencing?
Yes, Your Honor, if I may. Very few people, I think, in this courtroom have the experience of going into a jail to meet your client for the first time. I know Your Honor has. And it's a strange feeling to go in there, because usually when we go in there, Judge, we've read a police report, and in some of those cases it describes something just horrible. It's just a terrible thing that's happened. And we go into those jail cells and we see this client, and we're looking because we're expecting to see horns and the tail and the pitchfork. That's what is being described. And we get in there and we see just a person who is now facing jeopardy due to the worst thing that she's ever done in her life. And whatever else has made this person that way is not in the guideline scores. In my client's case, Judge, as you've read the pre-sentence and the people have read it and it's been admitted, her biological father, my client's biological father, died when she was 8 years old. And he also sexually and physically abused her, which means he began before she turned 8. And as the court is aware, we don't catch these guys the first time, and especially when force and violence is used, they can hide their transgressions for years. Once this man is out of her life, another man comes into her life, her stepfather, who does the same thing until she's old enough to move out of the house. The court is also aware that my client has also had the burden of mental health issues. And quite frankly, the reality is when people are conditioned to believe that that's the sort of treatment that they deserve by their father and their stepfather, and their mother's not going to protect them, they tend to seek out that sort of abuse in the spouses. So the abuse continues all through the youth of her life until she finally frees herself with this man. And what does she do when she frees herself? She puts without resources, she has no wealth. Without resources, she puts herself through college. She puts herself through law school. She not just puts herself through, she's second in her class in college, and she's second in her class in law school. And she has, eight books from law school, which she's, jokingly told me that's twice what her stepfather had. They talked about those things. She goes on and she provides a home for her 3 children and her ailing husband while going to school full time, while being a mother full time, while working full time. She does all these things. But she makes a mistake. She makes one decision she shouldn't have made. She says yes. She has no criminal history. I couldn't find a speeding ticket. She raised dogs. She did Herculean stuff. When she got that phone call telling her that Timothy is either going to come to her or he was going to go into foster care, she says yes. Had she said no, I already have a house full of people I can't afford. We don't have the resources. Had she said no, my husband's sick. I have a 20-year-old son who's still living off us, sleep on the couch. Had she said no, Timothy would be alive today. And he would probably be in the loving care of a foster family, probably someone who can take care of kids with special needs. Had she said no, with her academic backgrounds, and quite frankly, given the fact of she has a relative in the legal profession who's highly regarded in the profession, she would now be practicing law and probably be doing very well at it, given her academic abilities. But she didn't say no. She did what moms do. She said, that's my boy, my baby. I'm taking him home, and I'm bringing him into the house. She brought him in knowing that she shouldn't have him there because she doesn't have custody. She brought him in knowing that she couldn't get him into schools and get him into because she didn't have custody. Her ex-husband was not going to assist her in that. She brought him in knowing she wasn't going to get any more financial assistance. It wasn't her intention for us to be here. It was never her intention. Something broke. If she said no, or if we wouldn't be here, something broke. Judge, this case makes no sense to anybody. There is no gain for her from this conduct. And if the court heard the transcripts of those emails, those text messages, she and Paul are unaware of the damage. They don't see it. How could you not see it? Because something's broken. There's no specific intent here. There's no intention. Her intention was to mother her kids like she did the other 2 children that were in her home household. That was her intention. Her intention was to provide, as she did with the other two kids. You don't see this with the other children. This is something about this boy and this woman broke. 30 years ago, we didn't know about postpartum depression. 20 years ago, we didn't know about postpartum psychosis. Someday, somebody's going to tell us what's wrong with this woman and why anyone would be capable of what she did. Someone's going to explain it. 400 years ago, we burned people like her at the stake because the bloodlust was there. And that's what made people feel better, and that was their solution to a horrible situation. Well, there is Mr. Roberts' description of this offense. Nothing's inaccurate. Nothing he said do I disagree with. But I think you have to add in the part that something's wrong here. Something's wrong here. And even if we can't put a label on it, we all know it. Timothy was her blood son. This wasn't some child. This wasn't a financial gain. This wasn't a stranger. This was her blood. She gave birth to this boy. And yet she was able to do what she did. Something's broken. The human mind just its capacities and its reasonings. I don't claim to understand, but we can look at her life before then and the circumstances, and they come together. And unfortunately, Timothy is the victim of it. That we get that. But the idea that this is premeditated or she intended, when they found the video show when she was surprised. She was surprised when he passed. Something's amiss. And I'm asking the court to respond to that reality. The easiest thing would be to exceed the guidelines. But I'm asking the court to do the hard thing, and that is to respond to reality. This is a person who, if she had said no, 10 years from now she'd be practicing law, and people would be asking her to come and to speak at high schools to talk about how you overcome what you've overcome. The mental health issues, the abuse from man after man after man. This was a survivor and a person who pulled herself up by her own bootstraps, no resources, all on her own, all her effort. This is what she's done as well. And it's unfortunate. It's horrible for Timothy. And it's horrible for her. But at the end of the day, we're not looking at evil, we're looking at sick. And I'd ask the court to apply that standard. Thank you.
All right, thank you, Mr. Johnson. Ms. Vander Ark, do you wish to say anything prior to sentencing? Well, first and foremost, for the individuals here to speak on Timothy's behalf, I appreciate you being here. It kind of struck me throughout the trial, who was here for Timothy. And at one point in time, I worried that we may not have anyone to give a victim impact statement. And that to me made me very sad, quite frankly. Horrified more than anything, but quite sad. And I'm happy that two individuals took time to be here from miles across the country. And out of a horrible situation, that makes me feel a little bit better. Not much, but a little bit better. Mr. Johnson makes the same argument today that he made at the trial, that this was just negligence. This was her not understanding what was going on. She was really trying to do the punishment. She was trying to be a good parent, and she just didn't realize that Timothy was in such a horrible condition. And I found myself, especially during closing argument, quite frankly, finding myself almost believing that. And afterwards, after the trial, I sat in my car after leaving that day, trying to understand, why I could feel that way. And what I realized is that I wanted to feel that way because I didn't want to accept the reality of the situation here. And the reality of the situation here is that this person, Ms. Vander Ark, you intentionally engaged in these acts. This wasn't negligence. This is not understanding why, but you intentionally did this with a goal. And I think Mr. Johnson's correct. I don't believe there was an intent to kill here, because you would have lost the very thing that you wanted to torture. Without him, you have no one to torture, except maybe the younger children. So I don't believe you intended to kill him. I think you intended to continue on torturing him for as long as you possibly could. The why, I don't know. But all the information that I have in front of me, and I sat down, I really thought about this, and I looked over my notes from the trial, demonstrate that this wasn't negligence. This wasn't you not understanding what was going on. You look through, I read through every single text message of the exhibit, 2,000 plus pages, to try to understand what the heck was going through your mind. And what became entirely clear to me is that you knew exactly what you were doing. Immediately afterwards, when police arrive at the home, you immediately concoct this lie about he's been on a hunger strike. He was in the bed and I checked on him and I gave him some food and all this stuff. You got Paul involved in it. At one point in time, put baggy clothes on him. Put clothes on him to make sure, I guess, that he looks like he was actually wearing them, that he was hiding his poor condition, even though you already received text messages, weeks earlier of how bad he looked. You testified yourself how highly intelligent you were. In fact, that's the only thing that you testified to that I think was actually true. You were quite proud of that, boasting how intelligent you were. And not only that, but your actions in hiding this child. You hid him from his grandparents. You made sure that your other son, G, or little man, as you call him, didn't see him. Those text messages talk about not wanting anyone to see him. I want to see him in that condition. You made sure that the garage was closed. When you sent him out, there was no pants on to clean out the garage. I don't want to believe it because I don't understand. I can't wrap my mind. I've been trying now for this entire case to wrap my mind around how somebody could do something so horrific, not only to another human being, but to their own child. I'm a father myself. I love my kids. I love them with unconditionally. But quite frankly, there's a mother's love that I've seen that is striking. And anybody who's a parent who's married, most mothers, and not all, but most mothers have such a strong love for their children. And to see what you did to your own child, I don't know if there's a word in the English language to describe how to describe it. I only can come up with just horrific. You intentionally and systematically tortured this child. And let's call it what it is. It's torture. You tortured this child. This wasn't punishment. This wasn't trying to curb his behavior. You tortured him. You monitored him obsessively. All the things you did. I looked through every one of the messages. Bread with hot sauce, wall sits, up and down the stairs, sleep deprivation, ice baths, making him puke up food, monitoring his bathroom time, giving him 60 seconds in the bathroom if he went to urinated, or 5 minutes if he had a bowel movement. You made him sleep in the closet. You threatened us to make him sleep in the garage. You put Tabasco directly in his mouth. You made him put his hands over the head. Made him work in the garage with no pants. And there's two other things that didn't come out in the trial that were in the messages. One, that there was talk of blindfolding him, depriving him of his physical sight as a punishment. And the last thing that struck me is just absolutely horrific in terms of your thinking. There was mentioning of giving him salt water as a punishment. One of the text messages talks about, hey, tell Paul or tell Tim that I'm not going to do the salt water punishment. And your reasoning for not punishing him was that, oh my God, we can't get him salt water, that could hurt him, that could kill him. But it was because you didn't want to give him another excuse to sit down on the toilet because he'd have diarrhea. He'd have diarrhea, and so he would have an excuse to sit down for a few more minutes while he was diarrhea from salt water. That was your excuse. That was your justification, not that it would hurt him. And you did so for what? Because of some punishment. You wanted to regulate his food, even though you yourself testified that he didn't really gain a lot of weight. Toward the end of these text messages, you and Paul are talking about not wanting him to win. He's not going to win. I didn't allow pictures to be shown in open court of Timothy as he was when he died because I didn't want people to remember him like that. Of all the things you took away from him, one thing I didn't want you to take away from him was at least some shred of dignity. And then I also thought, well, I'm a judge, I'm a human being. I don't know how to right this wrong. We try to do that. I try to do that from the bench every day. There's no way to right this wrong except impose a sentence that essentially takes away your freedom. And I thought to myself, what do I do? And I will tell you this. I'm choosing not to remember your son dead, looking like a Holocaust victim, but I'm choosing to remember like that. And you can't even look at him. That's how he was. A beautiful child with a lot of life in his eyes. That's who your son was. And you took that from him. I'm choosing to remember him as a happy individual with life, not as an individual. And that's the picture I want people to remember of your son. You took that from him. You took it from him. For what reason, I don't know. Mr. Johnson's right. There is something broken in you. I don't know what that is, but it doesn't negate what you did here. So besides remembering him like that, I'm not going to let you hide in the darkness anymore. People know what you are now. They know what you did. You're not able to hide in the darkness anymore. Timothy won. And he won because we know what you did to him now. It's not hidden anymore. We know who you are. That's the way that I'm going to honor him. You don't win because justice, thank God, in this case prevailed. I can't even imagine if you had been able to resuscitate him. He'd be still suffering. So if there's anything I'm grateful for, would be that he finally passed away so you couldn't continue to torture him like you did. It's a sentence of the court. First says to count 2, child abuse in the first degree. Court sentences you 50 years to 100 years in prison. Credit for 575 days. Court is exceeding guidelines in this case. The court finds that the amount of torture that I've indicated in terms of the long-term suffering that Mr. Ferguson, Timothy went through justifies on a reasonable grounds to depart from the guidelines. Used to be the standard was the guidelines. If the guidelines had taken into consideration all the elements, I don't think they would take into consideration the amount of absolute systematic, consistent torture that you engaged in here. I think that's enough reasons to justify departing from the guidelines. There's a $68 state cost, $130 crime victim rights assessment. As to count 1, felony murder. It's a sentence of the court that you serve a term within the Michigan Department of Corrections for the rest of your natural life without parole. Again, there's credit for 575 days that you've already served. There's a $6 to $8 state cost. The crime victim assessment fee has already been assessed, and the court is going to assess a $450 public defender fee. Ms. Vander Ark, you have a right to file an application, you have a right to file an appeal. Request for this, if you are unable to afford an attorney, one will be appointed to a public expense. Request for assistance to the lawyer must be made within 42 days from today's date. Clerk is handing you a form that you must complete, return to the court in that 42 days. Mr. Roberts.
Judge, just briefly, I believe you did indicate you would order that $5,000 in restitution.
Oh, I did. Thank you, Mr. Roberts. The court will order $5,000 in restitution at this time to the Michigan Department of Health and Human Services with the caveat that Mr. Johnson, you can certainly, if after the documentation, you can certainly ask for a restitution hearing and to contest that amount.
Thank you, Your Honor.
Anything else for the record, Mr. Roberts?
No, thank you, Judge.
Mr. Johnson?
No, sir.
All right, we're adjourned.
Yes,
That kills me for being able to stuff.
we'll ask for it.
She seems pretty engaged there. She seems pretty engaged with her counsel there. So, seems pretty engaged with counsel there. All right, we're going to play Paul's sentencing. Then we're going to wrap it up for the day. Then we're going to show Afro Man's press conference. And then we'll be done for the day. So, all right, Shanda, here you go. Waddle off. All right, so we're going to show Paul's sentencing, because remember, Paul thought he was going to get off. Paul thought he was going to get slap on the wrist, maybe. I don't know, something really light. Actually, I'm not sure what Paul thought he was going to get, to be quite honest. I really don't know what he thought he was going to get. But all right, let's check out Paul's sentencing. I can take this off. Okay, so this is Paul's sentencing. This is from February. All right, let me just post this here, and then I'll go ahead and play it. All right, so this is Paul's sentencing. Paul Ferguson. Is it Ferguson? Really, pants? Come on, Super Bowl. Yeah. Super Bowl. Paul Ferguson's sentencing from. All right. Now, you guys were saying, I asked if you thought that she should get a new trial, right? I asked if you guys thought that she should get a new trial. 567 votes. 95% of you thought she's still guilty, so no new trial. Oh, I'm sorry. Did Mr. Johnson represent her properly? So 95% of you said yes, she's still guilty. 5% of you said you think she should get a new trial. Interesting. All right, Gordon. Yeah, no, she actually was just fed. She's been fed. We need to feed ourselves. Kitties have been fed. All right. Yeah, interesting. 95% of you said no new trial, and 5% of you said she should get a new trial. So, all right. So this is Paul's, as you can see, his sentencing hearing. This is from February 26th. So hers was January 25th. This is February 26th. So a month later. So definitely watch his expression, because I think he thought he was going to get something different.
All rise. Come to order. 14th Circuit Court, County of Muskegon is now in session. The Honorable Matthew R. Casel is presiding. And you may be seated.
before the court is file 22-3537 FC. It's people of the state of Michigan versus Paul Ferguson. Are you Paul Ferguson, sir?
Yes, sir.
Answer verbally.
Yes,
Are you
sir.
Paul Ferguson?
Yes.
All right. Mr. Ferguson appears before the court with his attorney, Mr. Joshua Eldon Brady. The people are represented by Mr. Matthew Roberts. Same time scheduled for a sentencing in this case. Had the people had a chance to read the pre-sentence report and the attached guidelines?
We have, Your Honor, we have no corrections to that, although I know the court is in receipt of a letter this morning, as we all are, from Paul's older brother. We have no objection to that being included in the report as well.
Is that any objection to? I did receive a letter from Nolan Ferguson, who was here in present for Shanda Vander Ark's sentencing. And I did receive that this morning. I didn't have a chance to read that before I came on the bench. Do you have a copy as well, Mr.
I have a copy, yes, Your Honor, and I have no objection to that either.
Okay. Also, the court is in receipt of 2 assessments, psychological assessments. One is from a Thomas D. Shazer, psychiatrist, forensic psychologist for Ann Arbor. It's 25 pages in length. That was submitted by defense counsel at the urging, I will say, of the court, asking for that, so I appreciate that, Mr. Alvin Brady. I also am in receipt of a report from Sami Farhat, a PhD, licensed psychologist. This is a 7-page report. It's a psychological assessment as well. It was also provided by defense counsel. Court has reviewed those in anticipation of sentencing. Mr. Roberts, have you received a copy of those?
Yes, I have.
And Mr. Alvin Brady, and any objection to the court reviewing those and considering those as sentencing, Mr. Roberts?
No, Your Honor.
Mr. Alvin Brady?
No objection, but I would ask those be considered as non-public exhibits.
Yeah, the court is going to have them scanned into the court file, but they are going to be non-public. They do contain a large amount of what I would consider very personal medical information that I don't think is appropriate to be in the public domain. The court is going to reference certain conclusory conclusions from these reports, but those do not reveal specific medical information. I think it's appropriate, so the court will make these part of the record because it's going to be consider those in sentencing, but again, it's going to be non-public. So, all right. Any additions or corrections you have to the pre-sentence report, Mr. Roberts?
Beyond that addition, no. I have none, Your Honor.
Okay, Mr. Alvin Brady, have you had an opportunity to review the pre-sentence report and the attached guidelines?
Yes, I have no additions or corrections. I would also note, as we're on the topic of letters, I submitted a letter from Stephen and Martha Vander Ark. Those are Mr. Ferguson's. I believe those would be step-grandparents, the current placement of his younger half-brother, G. They had intended to be here in support this morning, but were ill this weekend.
Okay, yeah, I have also considered that too. Did you receive a copy of that as well, Mr. Roberts?
I did.
Okay, I've read that too. I've gotten a large number of letters from people that I would say unrelated to this case specifically, just individuals who saw it on court TV and expressing an opinion. I am not considering those in sentencing because, one, they're not directly connected to the case. And I do appreciate the comments from individuals, but I think it's important we limit to the record to people who actually have something to do with this case or connected with the victim. So unless there's an objection to that, I've read them, but I'm not using it as a consideration. So any objection to that, Mr. Roberts?
No.
Mr. Alvin Brady?
I would note, not having seen copies of those, I can't comment on the specific letter, but no issue with that, Your Honor.
Yeah, I mean, there's just random people who saw it on TV, and I just don't think it's appropriate for the court to take that into consideration for sentencing purposes. I don't think that's fair to Mr. Ferguson. So, anyway. So no additions or corrections, Mr. Alvin Brady?
No additions or corrections.
All right. And Mr. Ferguson, have you received a copy of the pre-sentence report and the attached guidelines?
Yes, Your Honor.
Any additions or corrections you have?
No, Your Honor.
And have you had an ample opportunity to discuss the contents of that report with your attorney?
Yes, Your Honor.
All right. Mr. Roberts, do we have any victim representative who wishes to make a statement today?
We do not, Your Honor.
Okay. Any comments regarding sentencing?
Yes, Your Honor, thank you. As I've said to the court before, this is as it relates to Paul, this is one of the most difficult cases I think I've ever had to deal with, not just from the standpoint of how difficult the subject matter was here, the tragic death of Timothy and the circumstances surrounding it, but just with Paul himself, and I'm not saying anything today, really, that I haven't told Paul in multiple meetings that we've had in leading up to the trial and his cooperation here, that I view him as favorable in that he was willing to help us and to testify against his mother, which I'm sure was very difficult for him to do under the circumstances, but that I was also angry, just frankly angry and shocked and appalled at his treatment of Timothy, because he was, for all intents and purposes, the enforcer arm of this two-person, the two people most directly responsible for Timothy's death, that he was the one that would deal out most of the punishments that were directed by Ms. Vander Ark, and certainly she's received the appropriate sentence for her role in this as well. So I had mixed emotions about Paul, even up to and including the time that he testified in this trial, and those frankly continued. One of the things that we discussed at the time of the plea was giving Mr. Eldon Brady an opportunity to get the evaluations, which we now have, in an effort to hopefully demonstrate in some regard why Paul did these things. Was it a psychological condition? Was there some manipulation taking place? And quite frankly, I think, just as my feeling is there's good and bad with Paul, I think both of these assessments reflect the same thing. What is absolutely clear from both of these assessments is that whatever upbringing Paul had from his mother and frankly from his father as well, led to him being how he is today. And that was a childhood that I think both reports indicate was marked with abuse and neglect, a very traumatic upbringing, moved around a lot, and what also rings through in these assessments is that nobody did anything to get Paul any help when it could have made a difference. So that is, in some respects, that's the good part of this, because it does seek to at least explain in some regard why Paul behaved the way that he did. But there's bad in here as well, and I'm sure the court will note this, but the one sentence that struck me in Dr. Shazer's report is that it says, in my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's presence and active influence in his life. That's frankly scary. And there's other scary parts of this as well that indicate that Paul was, at least in some respect, predisposed to being essentially a bully. And that's how you could view his behavior, is that he was a bully. Now, nobody, I think, would expect any bully to take it to the extreme of actually killing a person, although certainly it does happen, but nobody would expect that was an intentional outcome that Paul sought here. And we can't lose sight of the fact that Paul didn't become this way in a vacuum, that his upbringing in some respects led to him being predisposed, as this report indicates, and I think the other report references it as well, that he was predisposed to already doing some of these things. Frankly, I think that Ms. Vander Ark took advantage of that and used Paul because she saw an opportunity to have Paul do the horrible things that she couldn't do herself or wouldn't do herself, but be done at her direction. And Paul was unfortunately willing to go along with those things because of everything that had happened to him, because of his traumatic upbringing, and because of the conditions that he did have that led to that. So it's hard to balance these things out. Certainly we did not have this report at the time that Paul pled, and I don't know that in looking at this report that the decision that was made in this case would be any different, but certainly there are things here that would have been nice to have been able to consider, but we didn't have the benefit of that. And as I told the court, I think I've told the court on several occasions in speaking to the jury, they were, in Ms. Vander Ark's case, very much impressed by, might not be the right word, but certainly factored in Paul's testimony a great deal, believed that he was telling the truth, believed that he was honest about what his role in this and Ms. Vander Ark's role in this. So I think his testimony was instrumental in achieving the conviction that was achieved here against Ms. Vander Ark. So I certainly owe Paul that consideration, but beyond that, I certainly don't envy the position the court is in today. In balancing everything that has taken place here, the good and the bad, even in this report, and the good and the bad with Paul, I will stick to the agreement that we have made here. I will ask the court to sentence within the sentencing guidelines in this case. Certainly the court is obviously free to exceed the guidelines if it feels there's a basis to do so, and quite frankly, there are reasons to exceed the guidelines. In some respects, there's reasons to go below the guidelines as well. So literally, I think any number that the court chooses to pick here, I think would be the appropriate sentence, because I think it's a difficult balancing act that the court has to do here. But my commitment was and continues to be that we would ask the court to sentence within the sentencing guidelines. I would ask the court, however, to impose a maximum number here that is essentially equivalent to what Paul's life expectancy would be. And the reason for that is that if some of the bad that's indicated in these reports is actually present and Paul does not receive treatment for that, and those conditions that are noted here, most notably the potential antisocial disorder, essentially a sociopath, if those things are borne out in the prison system, that the prison system then has the opportunity to keep Paul locked up as long as possible. I hope that he can get some treatment inside there, but the bad in here has got to be addressed, and if it's not, then certainly Paul does represent a threat to the public moving forward because of his disassociation, essentially, from feeling empathy or feeling bad about the things that he had done. In the moment, it did not appear that Paul felt bad about those things. There certainly was a moment where he thought he needed to let his mother know that Timothy was very thin and that they should start feeding him, but overall, what comes through in these reports is that for the most part, those were absent. And the text messages, I think, even bear that out as well. That even after that noting of the fact that Timothy was very thin and that they needed to start feeding him, Paul was still a willing participant in the truly tragic and horrible things that happened in the last days of Timothy's life, including the prolonged ice bath that Paul watched over. So certainly that bad needs to be addressed as well. So again, I don't envy the position the court is in today. I will stick with my commitment here and ask the court to sentence within the sentencing guidelines. But quite frankly, any number that the court picks here, I think would be an appropriate sentence for Mr. Ferguson. I'm pleased that we've been able to achieve whatever justice we could for Timothy here in both of these convictions, and certainly the two people most directly responsible for what happened to Timothy are going to, in all likelihood, be incarcerated for an extended period of time, certainly in Ms. Vander Ark's case for the rest of her life, which is completely justified under these circumstances. So I would ask the court to, as it will have to do, to weigh the good and the bad here in these reports. And I trust the court's I trust whatever decision the court makes here.
All right, thank you, Mr. Roberts. Mr. Eldon Brady, the elocution.
Your Honor, I'd like to start by responding to a point that Mr. Robert made before I go into the multiple points I plan to address. I understand the prosecutor's characterization of Paul as being the enforcer, as being the primary one. But I believe part of that is based simply on the evidence that we have. This court's heard the text messages, extensive text messages, of Ms. Vander Ark instructing Paul on what he was to do to Timothy. You've heard Paul's testimony about what he was instructed to do and what he did. The rest of the time, when she was there doing whatever she did, Paul was at work. She didn't have to send text messages to herself. Timothy's not here to talk about what happened when it was just him and his mother. So I disagree with that characterization. I believe, based on what we do know of Ms. Vander Ark, that there was far, far more that went on. There was far, far more that she did that there simply is no evidence of, no one to speak of, because the only person alive who knows what she did is her. Beyond that, reading the pre-sentence report in this case, I can't argue with the reasonableness of the recommendations in the pre-sentence report. I also really can't add anything about the offense, about the details of what happened to Timothy. You presided over the same trial that I watched. I know in motions other paperwork submitted to the court. You're aware of far, far more than what came out publicly, what was submitted to the jury. But I'd ask the court to consider, I think there's 5 fronts on which Paul should be evaluated very differently than where his mother is. And the first is just capacity to understand. We heard Ms. Vander Ark's attorney argue they didn't know what they were doing. They didn't realize that it could kill him or cause that level of injury. And I don't have to come to a conclusion. I don't have to say I think that's right or that's wrong to understand that a 41-year-old law school graduate who was, by her own boasting, at the top of her class, who passed the bar with flying colors, who would have been an attorney, well, academically was qualified to be an attorney. We never got an answer of why she wasn't. And who worked for the court, both from a legal front, from a moral front, from an intellectual front, had far, far more capacity to understand what she was doing and the potential consequences of what she was doing than her son, who was a 20-year-old high school graduate who worked as a dishwasher. There's simply no comparison in capacity, in life experience, in an ability to understand and recognize what was happening. Second, well, we recognize, for purposes of the child abuse statute, for purposes of Paul's plea, the law may not distinguish between a parent and another person over the age of 18 who's placed in charge of a child. We all know a mother has a very different role than a sibling. We all know that there's a certain level of rivalry, a certain level of competition that we expect between siblings, which is very different than the care that we expect from parents. Third, I'll come back to the text messages. It was very clear Paul was the follower and his mother was the leader in this case. Listening to over an hour of text messages read during her trial, there's pieces missing. We don't get the whole story because she talked to him over the camera, or she talked to him on the phone, or she talked to him in person. But what is very clear from those text messages is there is not a single time that Paul gives an instruction. Every single time an instruction is given, you need to do this, it is given by her. Fourth, and Mr. Roberts has addressed this regarding Paul's cooperation. Once the gravity of what happened sank in, I believe from the reports that was a day or so after, Paul has shown remorse. He's shown confusion over how he could have done this and recognition that it was wrong. He's testified honestly. He's fully cooperated in many areas in ways that were not of clear benefit to him. His mother did none of these things. She took the stand and lied, redirected. It's not my fault. I didn't do anything wrong. And fifth, and I think very important in looking at the evaluations of Mr. Ferguson, it's very clear that he and his other siblings were also victims of their mother. CPS involvement going back to when they were in elementary school, back when Timothy was 18 months old. A third grade teacher who said Paul and Nolan are secretive about what happens at home. They're not supposed to talk about it. So when Mr. Johnson argued in cross-examination to Paul, why didn't you report it to somebody? A lifetime of being told you're not supposed to talk about what goes on at home. A lifetime of being isolated, separated from peers, having no meaningful social contacts outside his household. That all started with her. A record that when Timothy was 18 months old, when Paul was 7, that Timothy was underfed, failure to thrive. Paul didn't have anything to do with that. He was 7. But that was the pattern. That was his entire life. That was his entire framework. That was what she taught him from the beginning, or at times failed to teach him through neglect. Mr. Roberts referenced, and I don't remember if it was in sentencing or in his closing argument, that the difference between Timothy and Paul was that Paul was useful. Timothy wasn't. At least not to their mother. And I wouldn't disagree with that characterization. But I think that's important for the court to consider. Timothy was treated the way he was because he wasn't useful. That's how children in their mother's household were treated if they weren't useful. And I believe at some level, some part of Paul understood that. He understood that we do these things to Timothy because he misbehaves, because he doesn't follow instruction, and because he's not useful. And part of understanding that is also understanding that if he didn't follow instructions, if he misbehaved, if he got on her bad side, that he could once again be subject to some of the same mistreatment. On the neglect front, I don't think any of them ever ceased to be subject to that mistreatment. And I'll end with his mother's own words from the text messages read in court. To Paul, quote, "If he falls asleep for you, from you, not watching, that is not going to end well for either of you." Thank you.
Your Honor, if I could just make one more brief point, and it's not in response to anything that Mr. Eldon Brady has said, but the court referenced that it's had a lot of outside people contacting the court. I certainly have had that as well. And one of the consistent themes there is people believing that Paul suffers, or not suffers, it's not a suffering, that Paul is on the autism spectrum. I think it's important to note that in both of these evaluations, that's not borne out. Certainly people may have that belief and think that that should be a factor here, but there's nothing in either one of these reports that supports that conclusion. So I just want to note that. That is certainly something that I think the court could have considered, but there's nothing in the report that would support that, and I don't think Mr. Eldon Brady would disagree with that point.
Yeah. I was going to reference that in my comments as well, so.
Your Honor, I think the reports do bear out that some of the characteristics that those individuals are observing and coming to that conclusion are connected to that neglect and abuse, and I believe it was Dr. Farrak characterized as normalization of abnormal behavior. So while I agree that both analysis seem to have come to the conclusion that that diagnosis is inappropriate, I don't believe that those observations by the individuals mentioning that are ungrounded. It's simply that those behavioral characteristics come from a different source and therefore do not lead to the ability to officially diagnose with that condition. That does not change the fact that those characteristics are there, that those characteristics are relevant to Paul's interactions with his mother, or that those characteristics are relevant to ongoing treatment services that Paul will need moving forward.
Okay. Mr. Ferguson, anything you wish to say prior to sentencing?
Yes, Your Honor. What reasons could justify my actions? I could make up 1,000 and never believe one. What words could voice my regrets? I can think of millions, yet never feel it's enough. If I could do it all again and do it right, I would. I feel I will pay for my choices and yet never feel better because he's still gone. I have had time to think during my time in Muskegon County Jail, and I've realized many things about myself that I might never have considered otherwise. My problems and flaws, to put it simply, are the place to begin correction of self. I ask the judge for nothing more than mercy and fairness, to offer me compassion so I might learn from him. I only hope to better myself in the coming days and serve my time with what little honor I have left, and to make right my faults in search of a better tomorrow.
First and foremost, as Mr. Roberts referenced, the court is was in a difficult position. This particular case, I think a lot of individuals saw Mr. Ferguson testify, and I think there was concerns about intellectual potential disabilities, and the court was concerned with that as well. There was also a concern whether Mr. Ferguson was the target of manipulation on behalf of his mother, and the reports that were submitted to the court really did help me a lot in trying to parse those issues out. The report specifically by Dr. Shazer is very in-depth and very well done, and I thank him for doing such a detailed analysis. So the first concern of the court was whether or not Mr. Ferguson was suffering from some sort of intellectual disability, whether it be autism or something else. And there's a couple references to that throughout his Dr. Shazer's report. And specifically, the first reference that the court had highlighted was on page 2 of the report's first full paragraph, and it says, in my opinion, he, referring to Mr. Ferguson, was clearly either psychotic or suffering from symptoms of a mood disorder at the time of the current interview. And he was apparently functioning within at least the normal range of intellectual ability at this time. Thus, in my opinion, he does not suffer from a chronic psychotic disorder, a chronic mood disorder, or an intellectual disability. There's another reference more to the end of the report where he indicates, thus, his referring to Mr. Ferguson, his educational history is inconsistent with him suffering from intellectual deficits, and as noted above, he was apparently functioning within at least the normal range of intellectual ability at the time of the court interview. In my opinion, the defendant clearly does not suffer from an intellectual disability. So the court, that was helpful in the court because and some of the letters that I received as well, Mr. Roberts indicated that there was concern that Mr. Ferguson was autistic. And I think probably more toward that was easier to maybe manipulate him and that kind of thing. And certainly the court does take someone's intellectual capacity into consideration. I think it's important to understand the full situation. So the court, and although those are two small portions of the opinion that the court referenced, they're borne out by much more in detail history in Dr. Shazer's report. Specifically, Dr. Shazer analyzed every statement that the defendant gave the police. He also watched the testimony of Mr. Ferguson, interviewed him himself. He also looked through his history from the Oklahoma Department of Health and Human Services. He looked through his history from school records, from various psychological assessments that were conducted throughout his life based on the report. So I think that opinion is well grounded in not only his interview, his review of educational records, his review of mental health records, and everything else, Health West records currently from when he was assessed when he became in Muskegon County Jail. So the court finds that to be quite persuasive in terms of whether or not Mr. Ferguson is suffering from any intellectual disability. And the court concludes based on this report, well-written report, well-grounded in fact and history of the defendant, that he was not suffering from an intellectual disability currently or at the time of this offense. The second thing is whether or not Mr. Ferguson was somehow manipulated or coerced by his mother. I think all of us would like to believe that this is a product of manipulation, that this is simply somebody doing something that they were told to do, that they were afraid. Mr. Eldon Brady mentioned it in his allocution regarding the specific text messages. Well, those specific text messages I heard as well at the trial. Shortly after the trial concluded, I asked the prosecutor's office for a complete copy of every single text messages that would occur between Ms. Vander Ark and Mr. Ferguson, because I didn't want just the snippets, the kind of highlights or the real juicy stuff, for lack of a better term. I wanted to understand completely what the conversation was between these individuals. I read every single text message, every one of them. I think there's thousands in there, and I've read it 3 times now. 3 times in total. I read it 2 months ago, I read it a month ago, and I read it last week Friday. The entire afternoon was spent reading through these things, and I think it's clear to me that Mr. Ferguson, although he says that he was scared of his mother, or there's an allegation of that standpoint, I find that just the opposite to be true based on those text messages. There is some mention about punishment, but I think Mr. Ferguson, in my opinion, being submissive, for lack of a better term, to his mother was a result that he really had nowhere else to go. He had been kicked out from his father's house for failing to obey his father's rules and for other things. And he went to his mother's house, and I don't think Mr. Ferguson really had anywhere else to go. I think he was sort of beholden to his mother in terms of, well, there's going to be consequences. Although there are some text messages, 1 or 2 of those that bear that out, this strikes me in the text messages as more of a collaborative effort. In fact, there's some text messages where Ms. Vander Ark actually tells Mr. Ferguson that if Ms. Timothy does not behave, essentially, I'm going to leave him to you, as in that he's going to let the dog out and just bob off the chain. And Mr. Ferguson also several times essentially tells his mother things that are going on that are bad. And I think it's because he wants his mother to give him the permission to go ahead and engage in punishment. So in terms of whether or not his mother, he was somehow afraid of his mother, I don't think that to be the case. Now, that was my initial feeling about it and what I took it as, and that's why I wanted the assessment regarding whether or not he was being manipulated. And luckily, we did get one from the second one I referenced, which was from Dr. Farhat, which is specifically, I think he was asked to assess this particular question. And in the beginning of his assessment, he says that specifically, I was asked to assess whether Mr. Ferguson possessed a psychological disorder of traits that would render him significantly susceptible to manipulation, coercion, or suggestibility. After conducting the evaluation, I could not substantiate these traits as they pertain to the commission of the offense. As such, this report will instead explain the nature of the evaluation and my overall opinions regarding Mr. Ferguson's psychological functioning. He also opined regarding his intellectual abilities. He says, from a diagnostic standpoint, I did not find sufficient evidence to support Mr. Ferguson meeting criteria for any specific mental disorder While one may consider whether his presentation suggested a neurodevelopmental condition, for example, e.g. autism spectrum disorder, I did not find this to be an appropriate label. Instead, I attributed his overall demeanor and presentation to factors such as a lack of socialization, normalization of abnormal dynamics and experiences, poor interpersonal skills, and emotional dysregulation. He also indicated later on that page that I was initially asked to evaluate whether Mr. Ferguson had a mental condition or traits that would have rendered him susceptible to coercion, manipulation, or suggestibility at the time of the offense. Ultimately, I could not arrive at this conclusion based on the totality of the available information. Available evidence noted that he was capable of appreciating the abuse towards his brother, that he was capable of recognizing the detrimental impact it had, and that he at times disobeyed Ms. Vander Ark and tried to provide his brother with aid and support. Furthermore, despite reporting that he was under Ms. Vander Ark's, quote, psychological hold, he adamantly denied that he was coerced or manipulated into enforcing the abuse. Additionally, he recognized to some degree pleasure in having power and control over his younger brother. In this sense, while I acknowledge that he reported experiencing fear and concerns of disobeying Ms. Vander Ark, I could not reliably substantiate his involvement as being a byproduct of suggestibility or coercion. So what this court is left to conclude is that Mr. Ferguson, the way I look at this is that Mr. Ferguson in these reports, and a lot of these, throughout the report, there's talk about how Mr. Ferguson bullied his brother when he was younger. There's a mention, his stepsister, who I think was allocated on behalf of his mother, or on behalf of Paul, Timothy, at Ms. Vander Ark's sentencing. It says the stepsister, and this is before the police even really told her about exactly what had happened in here. It says the stepsister reportedly told the police that, quote, she doesn't know how involved Paul was in this situation, but he is the biggest bully she has ever met in her life, and he found genuine joy in tormenting Timothy whenever possible.
Judge, for clarification, I don't think that was Millie, that the stepsister.
So maybe I'm wrong. Okay, so perhaps I'm wrong about that. But this was someone who, without even knowing the full details, reported that. In one of the interviews, Mr. Ferguson indicated that he liked getting praised by Shanda and admitted he liked having control over Timothy. He reportedly admitted having power over somebody feels good. Later in the interview, I asked him whether he had felt ashamed at the time when he was abusing his brother, and he said, quote, no, he had not. I asked whether he had recognized his action as morally wrong at the time, and he again said, quote, no, he had not. He then volunteered that on one occasion, quote, I sent her a photo of how thin he was, and when I asked why he did this, he explained that I was worried. When asked when he was worried about Mr. Ferguson, Ferguson replied that he had been concerned for his health, observing that he was nothing but bones. I asked him whether he had, at the moment, thought that this abusive behavior was wrong, and he replied that, quote, that thought never even crossed my mind. A treatment plan back from July 22nd of 2012 indicates that, quote, client, meaning Mr. Ferguson, sometimes bullies his younger brother, the decedent, Timothy. The report also mentions cruelty to animals, stealing, abuse. His mother at the time, back in 2018, told staff at the clinic he's become bossy, telling his siblings what to do. For Mr. Ferguson's part, reportedly, when commenting about his being irritable, he admits that this is due to his younger siblings not listening. He gets physically aggressive towards his younger siblings. He also tried to lock his younger brother i.e. apparently a reference to the decedent in the closet because his brother wouldn't listen to him. So the court read this and certainly looks at this as someone who is predisposed, I think was the ultimate conclusion, predisposed to abuse his brother. Specifically, the victim in this case, in a history of doing that. Now, I have no doubt in my mind that Mr. Ferguson is a result of years and years and years of physical neglect and abuse on behalf of his mother. No doubt in my mind that's borne out in this report. But the court is asked to essentially ignore the decisions or his behavior because of that, and to somehow say that we're going to minimize the damage and what he did in this case because of that. If the court started imposing that standard, I think we would be in real trouble, because every defendant that comes before this court has a horrible history, I would say. That's the reason they're here. People that have supportive parents and things go good for them typically don't come here. Now, that's not always the case, believe me. There's a lot of interventions, but everybody has a history. And what I was looking at is whether or not this is a product of his mother or his situation, and what I can conclude is that this is not. Mr. Ferguson is trying to shift blame from his mother, from him to his mother, to say that somehow, well, if it wasn't for her, I wouldn't have done this, or she's the one that did this. At the trial, well, at her order, he kept saying it over and over and over again, to just keep underscoring the point. And if that had been an isolated incident, if that had been one or two of these things, if that had been a punishment that he administered, maybe the court could accept that. But we have an individual who was in a household for 6 months, intentionally himself engaging in torture of another person. And he doesn't, well, I'm worried about my mom's going to say, clearly it's not borne out in these reports. He had the ability to disobey his mom. In fact, he was on the stand and almost boasted that, well, I gave him extra food. Well, weren't you worried about how your mom was going to be upset? I still gave him extra food. So what that tells me is that this has been a careful, manipulated story by Mr. Ferguson from the very beginning of this thing, that he's going to put the blame on his mom. I'm going to be manipulated. I have Asperger's syndrome. I have autism. I have Stockholm syndrome. There's mention of him saying, well, maybe I have Stockholm syndrome in here. No, this is an individual. What the truth of this is that we have two individuals that lack empathy, who lack emotion, and both of them, the triggering factor in this report, the triggering factor that caused this abuse was the removal of the husband, of stepdad. Once he was gone, these two individuals were free to torture somebody, and they did it. That's what they did. And I think Ms. Vander Ark did use Mr. Ferguson. I think that she knew from his history that he was predisposed to torment Timothy. I think that she knew that he would have no problem doing that. And Mr. Ferguson walked through that door and was happy to be the enforcer. Was happy to do it, and continued to torture his brother over and over and over and over until he was a shell of a person, until he was dead, died from starvation, died from hypothermia. He had no fat on him, barely any muscle on him. And the whole time, just letting it happen. The report says, it appears that the stepfather's presence in the home had prevented Paul and his mother from abusing the victim. Again, it wasn't anything to do, they were just holding him back, essentially.
The overall opinion, which I think is important, says, in my opinion, although the defendant's participation in the abuse was in a part a function of his social milieu and living situation, these contextual factors were not a necessary condition for his participation. As previously noted, mental health records contain information to the effect that while they were still living with their father and stepmother and reportedly had no contact with their mother, Mr. Ferguson's stepmother told the psychiatrist that he had become bossy, telling his sibling what to do, and the defendant himself that he would become irritable due to his younger siblings not listening. He gets physically aggressive, told his younger sibling. He also reports that he's gotten irritated with his siblings and has pushed them in retaliation. He's also tried to lock his younger brother, the decedent, in the closet because his brothers wouldn't listen to him. Consistent with this, Norton Shores Police Department documents indicate that Mr. Ferguson's stepsister told police that, quote, he is the biggest bully she's ever in her life, and he found genuine joy in tormenting Timothy whenever possible when they were living in the biological father's home. Notably, the defendant allegedly engaged in this abusive behavior despite there being any safety rules in place, and despite his father and stepmother disapproving of this behavior to such an extent that they removed him from their home once he turned 18 because of it. In my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's present and active influence in his life. Nonetheless, in my opinion, Mr. Ferguson's involvement in repeated acts of abuse that amounted to physical and psychological torture over a period of months reflects a general lack of empathy for his brother and a lack of remorse for his actions. Concludes that, in my opinion, there is no reason to believe that Mr. Ferguson's conduct disorder has remitted or that his participation in the abuse of his brother was not an expression of a persistent pattern of antisocial conduct. The court is concerned that Mr. Ferguson will not get the help he needs in prison. I think he's one step away from becoming a psychopath like his mother. And the court is concerned that he represents a danger to the public, that if released, he would represent a significant danger to the public. The charge here is child abuse. And I don't think this charge or the sentencing guidelines take into adequate consideration of the long sustained torture in this case. As I indicated in Ms. Vander Ark's testimony, there was a long period of months of various punishments, including bread with hot sauce. There's the hot sauce that apparently contains 2 of the hottest peppers that we have in the world. Wall sits for an individual who practically had no muscle left. Running up and down stairs, cleaning out a garage with no pants on, sleep deprivation in itself. Putting alarms on him so he couldn't move or sleep. Making him puke up food. There's bathroom timers. Sleeping in the closet with a tarp down, which quite frankly might be considered animal abuse. But we have a human being here. Making his hands over his head. And then at the end of his life, an 8-hour practically ice bath that killed him. So no, I don't think any of those things are adequately taken into consideration by the guidelines. And I don't think the guidelines, quite frankly, these guidelines don't justify Mr. Ferguson's actions. Mr. Ferguson, I think you are a product of your environment, but I don't believe you that you're sorry. I don't think you have empathy. I don't think you have any emotion whatsoever. And that's what scares the court. It really scares me. I think you're sorry that you're here. I think you're sorry you got caught. I don't think you wanted Tim to die either, like your mother, because you would get caught and you wouldn't torture him anymore. And believe me, I've tried to sit here and try to think, well, maybe Mr. Ferguson's not as bad as Mom. I think you're just as bad, if not worse. If not worse. Because you had a job. You could have, Mr. Johnson actually asked you, couldn't you have brought home a thing of food for him. You could have gone to a neighbor and said, hey, my mom's abusing him. You could have grabbed him and got him out of there. You could have done any number of things to stop this. And you chose not to. Your own brother. And this is where we're at. So, based on all that, it's a sentence of the court. You serve 30 years to 100 years, Michigan Department of Corrections. Credit for 592 days you've already served. Court's going to assess a $68 state cost, $130 crime-based assessment, no additional financial costs. Mr. Ferguson, you have a right to file an appeal on this case if you're found innocent. To retain an attorney who will be appointed to a public expense. Request for the assistance of a lawyer must be made in 42 days from today's date. Clerk is handing you a form that you must complete. Return to the court in that 42 days if you wish to request the appointment of an attorney on appeal or adjourned.
All right, so that's it for Mr. Ferguson and his face. His face is like to quote the Afterman. When his head popped up. All right, so that's going to conclude. Excuse me. That's going to conclude our coverage of Shanda Vander Ark and Paul Ferguson. Well, mostly Shanda Vander Ark. She had her Ginther hearing part 2. Part 1 was in November. She got sick. She was all panic attacky and all that stuff. So she couldn't continue. So thank you, Debbie. Thank you. Appreciate that. So it was in November. They continued it to today. She took the stand again, and if you guys want to watch it, it was it started at 10. If you go back, it's about 4 hours now. It started. Yeah, it started about 4 hours ago. So if you want to watch that, at the end of the day, she took the stand. No other witnesses. The judge is going to take it under advisement. He's going to write a written opinion. So we don't know when that's going to be, a week, a day, a month. I'm not sure when it's going to be. Probably won't be too long. But when they do show it, or when, I don't know if they'll show it. They're not going to show it. But when it's released, we'll follow up with that. So I'm going to say goodbye to you guys. And I say join us. We have a redirect. Aaron set up a redirect for Afroman. For those that watched Afroman with us the other day, he won his. He was the defendant, and he was being sued by the Adams County Sheriffs for posting what they said were disparaging remarks and videos. So a press conference did happen, but it wasn't shown until later. So we have those press conferences. There's 2 of them. They're real short. It's like 2 minutes each. I'm going to show his verdict, and then we'll show the press conference. So it'll be a real short stream, but I just wanted to share that with you guys. So anyway, join us there. A redirect is set up. If you don't trust the redirect, then click on that. And with that, no kitty toy review because Roger's still recuperating, even though he's acting like he's not recuperating. But here we've got this little action going on there. So Roger's back there. He's kind of recuperating, and that's Sid is in heat right now. So Houdini was in heat. Yeah, she's good. She's in heat. So Houdini was in heat, and she kind of is out of it right now. Now it's Sid's turn. The earliest I could get them in is April 2nd for one of them, and then the other 2 are going to be April 30th, where I'm on the list to get them if somebody cancels. So wish us luck. At least we got Roger fixed yesterday. So anyway, take care, you guys. Thank you for joining us today for Shanda Vander Ark. We are going to go check out Afroman next. Thank you to our mods for keeping our space safe and courteous and respectful. Really appreciate you guys, and thank you to Aaron. And with that, we will end this stream, and we'll see you over at Afroman. All right, take care, guys. Have a good weekend. Bye.